I beg to mention item number 14 of the daily list, Your Lordship.
Yes.
Your Lordship, my senior, Mr. K. in charge, appears in this matter, and due to some personal difficulty, he couldn't attend court today, Your Lordship.
Okay. Item 14
Yes, Your Lordship.
is for the petitioner.
Petitioner.
When do you want?
Any convenient date after 8 February, Your Lordship.
On request made on behalf of Mr. K.N. Jowdhury, the senior counsel for the petitioner. Please the matter after 8 you want.
8 Feb.
Okay. 15th February.
Lordship. Obliged, Your Lordship.
Lordship, I'd like to pray for listing of a writ appeal. Lordship, yesterday I had mentioned this appeal and Lordship had allowed for today, but it could not be listed as some certain defects could not be processed, Lordship, on time. Lordship, could it be on 1st of February? Much obliged.
My pleasure. I beg to mention for listing, my lord, I have for condonation of delay, my lord. It was last posted on 20/11/2023, my lord.
When was it last posted?
20/11/2023, my lord.
Okay. So, 7th.
Obliged, my lord.
May please, Your Lordship. I beg to mention for listing of a writ appeal matter, long pending case matter for hearing. It was last listed on 4/10/2023. It is possible, my lord, on Friday next, my lord.
Not this Friday.
And Monday, my lord.
Okay. Okay.
Monday.
May- May it please, your lordship. I beg to mention for listing of a writ appeal, lordship, for first, lordship. We have challenged the order of the learned single judge, lordship. It's an urgency.
Do some emergency.
Yes, lord. On first.
Okay.
Please, Your Lordship. With the consent of the other side, I beg to mention item number 15 of the daily list. Lordship, we have been recently engaged in this matter.
PIL.
PIL. We have been recently engaged in this matter. So we need some instruction from the client. So a week's consideration may be granted. After a week, any date, Lordship, as per Lordship.
You witness.
F for the Lordship.
Okay, on request
Lordship.
made by.
Wait, please, Lordship. Lordship, we want it on 16. Can it be on 6th of February, Lordship?
Request made on behalf made by Mr. F. Faridi, learned counsel for the petitioner. When do you want?
6th, Lordship. 6th February, Lordship.
6. Many cases are fixed actually. Okay. 6.
Much obliged.
Obliged.
May I please, Lordship. First of all, I beg to mention of a IA of a PI, Lordship, for the next week. On last occasion, Lordship, the Honorable High Court has directed the state to file affidavit in opposition, and they have already filed. So, Lordship, kindly.
9.
Please, Your Lordship, I beg to mention item 16. In item 16, we are the respondents. My senior is out of station.
Who's your senior?
Mr. S.C. Kyle, sir.
Okay, on request made on behalf of Mr. S.C. Kale.
And for the petitioner,
Okay, heard Mr.
SS Gupta.
Assistant for the petitioner. On request made on behalf of S.C. Kale, Leonard. Standing counsel.
Yes, Your Lordship.
No, Leonard is here.
Uh,
When do you want? After 1 week?
Okay.
After a week.
Lordship, I also beg to mention item 17. In item 17, we are the petitioner.
Okay, on behalf of, made on behalf of S.C. Kale and the LGL, on behalf of the petitioner, list after 1 week.
Ashok.
Item 32 for motion.
May it please, Your Lordship.
Yes.
May it please, Your Lordship. I am a bona fide purchaser, Your Lordship. I entered into an agreement with the respondent number 4, Your Lordship, to purchase a plot of land. And accordingly, I paid advance. And after that, I also verified the land from the office of the circle office and both in the sub-registry office. And I found that the land was free from any encumbrance. And accordingly, I entered into the agreement. Subsequently, I again paid an additional advance amount for giving possession. And I took the possession of the house. I invested some amount for renovation, Your Lordship. Thereafter, Your Lordship will find Annexure 3. All of a sudden, after a year, I find a notice being pasted in my house where I am in possession that this land will be taken up by the respondent bank, Your Lordship, since there is this land was a mortgage land. So, accordingly, I made a representation to the bank that please let me know. Your Lordship will find Annexure 3. Sorry, Your Lordship, Annexure 3, page 25. Your Lordship, I requested the bank in paragraph 3, Your Lordship will find that my client is interested to settle the dues of the guarantor, Miss So-and-so, provided the same is reasonable. Your notice does not specify the amount pending. I therefore request you through this notice to specify the exact dues so that my client can go ahead with negotiation for full and final settlement of the amount and for protecting the property. In the meanwhile, I also request you not to take coercive action since any such action shall adversely affect my client and her family. My client is a bona fide purchaser who was never informed about the property being encumbered by the owner. So Your Lordship, I made a representation that please let me know the amount, though I am not liable to pay the hard dues, but since I am already invested a huge amount, I am ready to settle the dues. But thereafter, all of a sudden, on 20th 1, 2024, I made this representation, and on 24/1, a notice was issued whereby I am informed that they are going to take the physical possession of the property.
Page.
Page, Your Lordship, we find page 27 is the type copy, Your Lordship, with reference to above so-and-so has part order by so-and-so dated 1912 and appointed accordingly. See so-and-so executive magistrate is hereby deputed to oversee law and order during and over physical possession of following secured assets: equitable mortgage of land and building measuring 10 lassa covered by dag number so-and-so, patta situated at Revenue Village, Dhekiajuli Town, 4th Ward, Moja, Dhekiajuli, under Dhekiajuli Revenue Circle. There, sir, the executive magistrate so-and-so fixing a date. Sir, Your Lordship, there is a typographical error. This is 3/2/24. Fixing a date on 3/2/24 to take physical possession of above mentioned secured asset. So, sir, we request you to provide concerned lot mandal on 3/2/24 for identification of land as per above mentioned details. So now they are going. I am ready to settle the dues. I have made them representation, and though I am in the loss, so that's why, Your Lordship, I am before.
But I appear to the respondent number 2 bank. It's the fact that, my lord, the property is supposed, the physical position is supposed to be taken on the 3rd of this month, of next month. My lord. As far as the position on outstanding dues, my lord, on that I'll have to take instructions and place on affidavit. So, my lord, because ultimately, my lord, it's a fact that money, my lord, though she is not the borrower or the guarantor, but she is claiming to be in possession of the property, and that is the property that we want to take physical possession. As far as the position of the dues are concerned, my lord, I'll have to take instructions on that. I'll file affidavit.
Okay, heard, Mr. B.
B. Pushilal.
Legal counsel for the petition. I'll issue note. Issue note.
না 1 থেকে 3 তো হচ্ছে না, 1 থেকে 3 কাটা আছে, 4 থেকে ধরবেন। ঠিক আছে, I will take off from 7th or 5, 6 আমি
What is going on? Okay, he should keep his video muted. Issue notice, no? State is a respondent here.
State, Your Lordship, the Deputy Commissioner as well as the Circle Officer.
MSRB Borel, Leonard, Governor Advocate, appears for the respond number 1 and 3. And Mr.
I am for 2, my lord.
A. Ganguly, Leonard. Standing Counsel. Standing Counsel, PNB, appears for respond number 2. How about 4?
4 is the private respondent, Your Lordship.
Petitioner to take steps for service of notice on respond number 4 by registered post AD within 1 week. List after 4 weeks. Till the next suitable date. This is what? Notice.
24/1/24, yes,
This is a notice.
yes, your lordship. Order.
It's not in order. It's a
The
communication.
lordships may say that physical possession
May not be interfered.
kept in abeyance till the next.
Will say no coercive steps be taken against
Your lordship, my physical,
Specify, lordships may specify physical possession.
till the next suitable date. The respondent bank is directed. Bank should be directed not to take physical possession of the property of the petitioner.
oblige you.
Item 1 and 2 for admission.
One, two, three. I think this matter needs time to hear this matter. So what I pray that yes, I just also inform my learned friend, let it be on 22nd of February, my lord.
In admission hearing. it's
Admission.
already-
Admission hearing. I was-
22nd of February.
Okay, on request made by the parties. Please stop. When do you want? 22nd?
22nd.
22nd.
22nd. 1, 2, and 3, I think.
1,
Yes.
2, and 3.
2 and 3 also.
Nuclear.
Oblige.
Manipur, okay.
Item 4 and 5.
May I please your lordship. My lord, this is a appeal transfer from Manipur High Court, your lordship, like. And I think, my lord, last time, my lord has fixed it for final hearing.
Mm.
Along with the applications, your lordship.
Yeah, for the appellant
Yes, your lordship.
in item 4.
Yes, your lordship.
4 and 5.
4 and 5. There are 2 writ petitions disposed of by common judgment by the single bench of Manipur High Court. Against that, we filed this 2 writ appeals, your lordship, separate appeals. And it's be transferred here by the Supreme Court as at the point of time that bench was available in Manipur. Yes, ma'am. This is my lord, regarding involvement of just associations of hockey, my lord may be also aware when my lord was there in the teachers started. It's a long history of litigations regarding this association, your lordship. And we always say that, my lord, sports in politics is healthy, but politics and sports is very harmful. That's the thing, your lordship. What happened is this, your lordship, in the year 2009, is the policy of one association, one game. The Olympic Association, my lord, in Olympic associations, my lord, they have taken a decision to have this type of one game, one policy. No, your lordship. So, my lord, one game, one association. So they have taken the policy, and my lord,
Who have taken the policy?
Indian Olympic Association. So, my lord, they disbanded that Indian Hockey Federation's women and men both, your lordship. So, my lord, at that point of time, Manipur Women's Hockey Associations and Manipur Hockey Associations, they were, my lord, affiliated to federations, Indian Hockey Federations. But Indian Olympic Association has disbanded those federations, and they have taken this policy of one game, one associations. Then, my lord, they formed this Hockey India and directed all the associations or all the states to have only one associations. So accordingly, my lord, the Manipur Olympic associations, they've suspended this 2 associations, your lordship, Manipur Women's Hockey Associations, Manipur Hockey Associations, your lordship. Then they form an ad hoc committee to look after the affairs of hockey in the state of Manipur, Your Lordship. Then, my lord, one fine day, my lord, two Olympians from Manipur who participated, represented India in hockey, they called for a meeting with all other, my lord, international player, other players and other associations. Then they formed this Manipur hockey. Before that also, my lord, these two associations, the earlier two associations, they had a meeting and they just took a resolution that they also form an association. But they haven't taken any official steps by filing particular appropriate applications to registrar and all to form the association. But our associations, Manipur Hockey Association, my lord, after taking that decision, we applied to the Registrar Cooperative Society as per rules to register our associations and carry forward with the associations. Apart from that, Your Lordship, we also approach Indian Olympic Associations, Manipur Olympic Associations, and Hockey India for recognitions, and they have recognized us as Manipur Hockey as the only association to take care of this hockey affairs of hockey in Manipur. Accordingly, till today, my lord, even the disposal of writ petitions and by virtue of, my lord, the stay order granted by this honorable court, still today, my lord, all the tournaments, state and internal and national have been organized by the Manipur Hockey, and all the players, my lord, who have been participated, representing India and representing Manipur, are through Manipur Hockey only. Even those the player who recently got its awards and all, they are through Manipur Hockey only. In fact, the respondents, my lord, that Hockey Manipur, even though they claim that they existed and the honorable London single bench said that they should be recognized, till today they are only on the paper. There's no tournament such organized by them. We are the association and they are not recognized by the Olympic associations, either in Indian Olympic associations or Manipur Olympic associations, and they are not recognized by the Hockey India laws. So, my lord, my humble submission today is, lordship, the honorable single bench, while deciding, there are two writ petitions, your lordship. Writ petitions filed by Hockey Manipur and one writ petition filed by Manipur Hockey, your lordship. Manipur Hockey filed a writ petition challenging the order of a registrar, directing the Manipur Hockey, the appellant, your lordship, herein, to change the name of Manipur Hockey and to modify its memorial associations. That order passed in the year 2022. Even though the Manipur Hockey was formed in the year 2009, after a long gap, your lordship, with much delay. And another writ petition filed by the respondent, private respondent here, for the direction to implement the set order passed by the registrar, the cooperative society. Then, after hearing both the writ petitions, by common judgment, the single bench disposed of the writ petition, saying that allowing their writ petition, dismissing my writ petition, saying that Manipur of the hockey should change our name and modify our memorandum associations, and the Hockey Manipur should be there. That's why, my lord, we filed this appeal, and the appeal is before your lordship. And, my lord, there are a few things which I wanted to point out here, but before we proceed to the merit of the case, your lordship. While deciding, my lord, the case, the learned judge made an error of coming to the conclusion that Manipur, Hockey Manipur, was formed by amalgamations of two associations, my lord, under the Manipur Cooperative Registration Act, Association Act, my lord, Society Registration Act. Then we are supposed to be change our name and a memorandum of associations, my lord, by saying that this my Hockey Manipur has been registered by proper amalgamations of these two associations, which is factually wrong, Your Lordship. What happened is this, Your Lordship, for the amalgamations of two associations, may I just have a copy? We have the copy of this society registration. Here, I hope, my lord, last time also we have submitted, required, my lord, to be against this Manipur Society Registration Act 1989. It must be in Parliament. Parliament. But anyways,
1989.
1989. Also.
You have, but you have. Yeah. What? Manipur Society's Registration, 1989.
Otherwise, my lord, another copy we can provide to us.
One is act, one is rules.
Yes, Your Lord. Section 12, Your Lordship. May I read it out? Section page number 6. Section 12, Your Lordship. Societies to have power to amalgamate with another society. Whenever two or more societies desire to amalgamate, the governing body of its society shall submit a joint proposal in writing to register for his prior approval thereto. No such proposal shall effect unless the proposal with the modifications, if any suggested by register, is confirmed by 3/5 of the joint members of the society concerned. An appeal shall lie to the state government if against any order of state government on such final appeal shall be heard. On such appeal shall be final, Your Lordship. My humble submission here is, Your Lordship. This amalgamation process, even though, my lord, by mistakes, the London Civil Bench has said that they have amalgamated up to section 12. Till today, my lord, till today, there is no application to the register by the both the parties. And, my lord, the second proposal regarding the clause number 2, confirmed by 3/5, it is out of question because they haven't, my lord, submit any application so far. Only, my lord, applications we have been submitted by the associations, two associations to till today. It was an application to the minister.
My lord, this was not an issue, my lord.
No, it is an issue. I'm sorry, my lord, it's an issue. It's an issue. It's an issue, please. It is an application to the minister, and minister directing for the, my lord, registration. It's clearly shows that, my lord, the political, my lord, pressure is there, my lord, without following the rules, without going by the rules of law, Your Lordship, because of political pressure, because they have been, my lord, recognized as a association, because of amalgamation to associations, Your Lordship. And regarding our associations, my lord, I will show it from the documents, Your Lordship. After a thorough inquiry, after we file an application to register to form this Manipur Hockey, after the thorough inquiry by the government, they allowed us for the registration, and in the inquiry report itself mentioned that till that time, there was no registry application from the respondent Hockey Manipur, Your Lordship. May I read it out, Your Lordship? The appeal number 97. 97, my lordship. There are two read appeals. Read appeal number 28, sorry, my lord. The number has been, my lord, changed.
Guwahati number.
Guwahati number.
Earlier Manipur number. What is?
Yes, no, no. 114 page number, my lord.
Read April 28.
Yes, your lordship. Yes, lord.
There were two writ petitions.
Yes, there are two respects, your lordship. Type copy is page number 117. Hmm, hmm. This my lord got this page 117. Internal page 15. My lord got it.
Yes.
Yes, my lord. Inquiry report by of Shri T. Pradeep Kumar Singh, Inspector CS.
No. 117 is not an inquiry. It is the continuation of one.
My lord, this the proper type. 117.
It is the type copy of the page 1142,
1166.
116. Type copy.
Okay.
Yes, ma'am.
Yeah.
Inquiry report of Shri Pradeep Kumar Singh, Inspector CS, into the matter of registrations of the proposed Manipur hockey submitted by Registrar of Society Manipur. In present so and so, my lord, I have given everything in detail. And the next page, your lordship, the fourth paragraph on the next page, your lordship. Here, my lord, first page, paragraph said memorandum association so and so submitted. We have done everything, my lord, according to the law. Fourth paragraph, your lordship. No resolutions, memorandum association regulations, and members list of the proposed hockey Manipur, the respondent here in your lordship, are not submitted. Only two objection letters are achieved. It should be received from them. Then the next page, your lordship, 119. Last but one para. It has been stated above the complete proposal for registration has been received from them, Manipur Hockey, while no such proposal has been received from Hockey Manipur. Registering authority is now to decide whether the proposal for registrations of the Manipur Hockey will be considered or not for registration. Registration of the Hockey Manipur is not considerable at the present stage, as complete proposal has not been submitted by the party also. This is the report of that, my lord, state government, my lord. 6th of November 2009. So this is the report of 6th November 2009. Your lord. So accordingly, my lord, thereafter what happened is this, my lord. We file one RTI informations, my lord, to register recently. And that's, my lord, and my lord, the reply given by the authority in that RTI questionnaire, your lordship, it is, my lord, we have filed it in additional affidavit in appeal number 28, your lordship. It's a 12th February, October 2023. We have filed additional affidavit regarding that RTI, my lord. May I read out, your lordship? Here, my lord, the reply says that there is no record as such.
Which page?
Yeah, my lord. Let me read out my application first, your lordship. This is page number 8 of this edition affidavit, your lordship. Annex R27. To the State Public Information Officer, Registered Cooperative Societies, Imphal Government of Manipur. I, the undersigned, is in need of the following information and mentioned here and below. Please provide me the certified copy of the amalgamation letter dated 12/11/2009 of Manipur Hockey Association and Manipur Women's Hockey Association, namely Hockey Manipur, and also please provide me the relevant information, certified copy of the following: proceeding of the amalgamation of the Manipur Hockey Associations and Manipur Women's Hockey Associations, namely Hockey Manipur, and other related documents of the amalgamation of the said two associations, yearly activity report of the Hockey Manipur since its inception, number of district units under Hockey Manipur, report of annual general body meeting year-wise, report of the annual general meeting with election term-wise. It's at 30th January 2023, my lord, we have filed this. Then, my lord, they have replied, your lordship.
So far this issue is concerned,
Yes.
they file another
Yes.
writ petition before the.
Yes, I'll come to that. I'll come to that. I'll come to that, please, please.
697.
I'll come to that.
And that is pending.
Yeah, I'll come to that.
So how they can?
No,
Manipur.
no, I'll come to that.
Single judge.
Please,
Last
please.
single judge, my lord. in Nepal.
My lord, my learned friend will give me some, my lord,
This textual
some
mapping
opportunity.
has never been placed before the learned judge. Who
We
first
apprise to
saw.
the court.
Therefore, my lord, it is something goes wrong. Submission goes wrong.
So,
This
my lord,
textual mapping
my-
has
my-
never been placed before
before
the learned single judge.
I hope, my
Therefore-
lord,
Sorry, I'm sorry.
this type of, my lord, decorum should be, my lord. Yes. My lord, page number 9. Shri Sujit Kumar Sukham, so this is the reply, my lord, application. So we reference to a letter dated 30th 1/2020, the information under so and so. The next page shows the reply. We reference to a letters number so and so, meet to my lord. Shukum RS and page number 10, your lordship. A meeting proceeding of the amalgamation of the Manipur Hockey Association and Manipur Women's Hockey Association, namely Hockey Manipur, and other related documents of the amalgamation of the said two association, copy enclosed. And regarding other, my lord, year-wise activities, number of districts unit, annual general body meeting, with for election, no records. Association is running without any records till today also. And we have taken, I'll come to. And proceeding of the amalgamation, my lord, and it doesn't provide any application, my lord. The RTI report also doesn't provide any application by two associations for amalgamation. Yes, I have, my lord, submitted to the honorable court. They have written only to the minister. This we will point it out, your lordship. This is also, we have annexed it. So, my lord. And then I'm sorry, my lord, I have to trouble your lordship by coming back to coming back to the paper book of writ appeal 27, your lordship, because one document is very important, because I want to show it to your lordship, I'm so sorry, my lord. Instead, just both the documents that we have to file, but my mistakes. The document of my lord is 99 R15. That's all. That's all. Yes, my lord. It's the 12th November 2009, an application to the Honorable Minister, Cooperation Manipur, not to register. Amalgamation of Manipur Hockey Association, Manipur Women's, and Women's Hockey Association, namely Hockey Manipur, training number so and so, my lord. With due respect, I am, Honorable Sir, with due respect, I am stated a joint special general body meeting of Manipur Hockey Association, Manipur Women's Hockey Association was held on Sunday, 18th October 2009 in the State Youth Center, Humalampa. This, and in this agenda item number so and so, my lord, all this, my lord. This is an application, just a simple representation in one sense, your lordship, to the minister. But as per my lord, the act, there should be a proper application to the registrar. Till today, they haven't done it. And this application was, my lord, the application was submitted on the day we received our registration number. So, my lord, then what happened is this, my lord, by not considering or by not by neglecting all this factual aspect, my lord, that single bench passed the order and the judgment, your lordship. And there, after my lord, after we received this RTI report, my friends are correct, my lord, we filed a new writ petition challenging their amalgamation process. This is writ petition number 697/2023 before Manipur High Court, your lordship. So my humble submission today, your lordship, we are challenging the amalgamation process as it was not done by law as per the Act and rules. But today, my lord, this writ appeal before lordship is going to be heard, my lord, without considering this the process of amalgamation which has been wrongly, my lord, come to a conclusion by the single bench. So, my lord, tomorrow, my lord, my writ appeal is allowed regarding the amalgamation process. It's saying that it's wrong. Writ petition was allowed. Then there will be a great problem. So, my lord, my only humble submission is we are not shying away from contesting this, my lord, in the writ appeal. In justice and fairness, or my lord, all that I am praying this, my lord can remand it back this writ appeals to be heard along with this writ petitions which is pending before this honorable Manipur High Court, and to go heard this question of amalgamations, my lord, together. So it has to be decided together. Otherwise, it will create problem, your lordship. So that, my lord, my only humble submissions in fairness, your lordship, is this, my lord, by remanding back this appeal to be heard again along with this petition which is pending before this honorable single bench.
But this was transferred from the Supreme Court, is it?
Yes, my lord. Because, my lord, division bench was not available at the point of time. So all that I am praying in this, my lord, to be heard again along with the remanding back to the single bench. My lord has the power, you know, can direct it to be heard again in single bench.
Now,
Consider-
how can a single bench hear writ appeal?
No, I'm not talking about writ appeal, my lord. Remanding back to hear the issue again by the single bench. My lord, in many of the cases, the division bench has the power to remand it back to the single bench to reconsider the issues again, your lordship. So all that I'm praying in this, to reconsider the issue again by going into the issue of the amalgamation process and to be heard along with the remaining the pending writ petition, my lord, the matter can be, my lord, decided for good, for final, whether it may be against me or it may be against them, your lordship. It may be in favor of me or it may be in favor, my lord. So, my lord, instead of lingering the matter, otherwise, my lord, after this issue, then the issue of this amalgamation will come up again, my lord. Then everything will be, my lord, in chaos. In that process, my lord, all the players will suffer. So all that I'm praying is this, lordship, without going into this, the merit of this writ appeal, as I have, my lord, demonstrated to the honorable court that this amalgamation process was wrong and it was never considered as per the facts available, as per the records available by this single bench, because it was not strictly, my lord, discussed in the matter. So that all the I'm praying is it can demand back, my lord. And my lord, my learned friend, if they are feared, my lord, they can accept this. I'm not saying away, my lord, from this.
Yes.
Well, let's come, my lord.
Yes. Not with your respect. Let me refer, my lord.
No. We are not entering into the merits right now. What this court is asking is that whether you are acceptable to the suggestion.
No,
No.
not can't be. I won't take time. I'll argue within the short perimeter. my lord. Let me refer to my lord. This is
So then let him argue first.
oh, yes.
So, my lord,
Then we'll hear-
as my lord, my additional affidavit is also record.
Yes.
My lord, my humble submission is, my lord, as this additional affidavit or record, Even though, my lord, my learned friends are going to, my lord, object that going back to the amalgamation process, my lord, this documents are record before this honorable court. So, my lord, all the time, my lord, we have to see this one-sided, my lord, decision without going through that, my lord, the process of amalgamation by the two societies, the associations, my lord, cannot be ignored. So, in merit of which, and in this affidavit, additional affidavit also, my lord, they haven't filed any reply. After we file this, so my lord, we have to. No, it's not a question of sarcastic.
Filing or objection to the additional affidavit is up to us.
No.
Filing or filing
See-
objection to
see,
the
like-
affidavit is up to us.
See, we please address to the court. It's not proper to address amongst its lawyers, like we have to maintain the decorum of this honorable court, Your Lordship. Then, my lord,
Just a minute.
yes, Your Lordship. So, my lord, as we have filed this appeal, then, my lord, I come straight to this, my lord, judgment of this honorable single bench. Why we have challenged this by filing the appeal, Your Lordship?
Yeah, referring now which writ appeal, which
Yeah, writ appeal to my lord,
27.
27.
page?
Yeah, my lord, it's my internet page is page 35-1.
351.
Yes.
35/1.
Mhm.
What they are putting like this.
Mm.
Internet page 35/1 R2. Up to 35/2.
Yes, my lord, that judgment starts from 35/4. Your Lordship got this. Your Lordship got it?
Yes.
Yes, ma'am. Writ petition number 724 of 2019 has been filed to issue a writ of mandamus directing respondent number 1 and 2 to implement and execute the order dated 22/1/2018 issued by the Secretary Corporation, Government of Manipur, a letter dated 14/1/2019 issued by Registered Societies Manipur. Writ petition number 916 of 2019 has been filed to issue a writ of cessory mandamus for quashing the order dated 22/1/2018 directing the petitioner herein to change its name and alter its memorandum within 3 months, to direct the respondent number 1 to consider the disposal of the representation 29/12/2017. Miscalculations also have been filed as applicant to vacate the interim order so and so, since the issue involved in party were once and same both the petitions are heard together and disposed of by this common order. The dispute pertains to the registration of two societies, namely Hockey Manipur and Manipur Hockey. Hockey Manipur filed with petition number C of 724 of 2019. Manipur Hockey filed with petition number C of 916 of 2019. For the sake of convenience, the parties are referred to Hockey Manipur and Manipur Hockey. Heard Mr. So and so and so and so. Case of Manipur Hockey is follows, Your Lordship. The factual parts, I read it out, Your Lordship. Hockey Manipur is a registered society and has been formed by the amalgamation of two registered societies, namely Manipur Hockey Associations and Manipur Women's Hockey Association. On 1/6/2009, the president of the then Indian Olympic Associations wrote a letter to the President of Manipur Olympic Association stating that the Indian Olympic Association has just affiliated the Indian Hockey Federations and Indian Women's Hockey Federations and provisional affiliations has been given to one association, namely Hockey India. The aforesaid letter further states that Hockey India shall work on the principle of one game, one body, and shall thus give recognition to one body in each state union territory to control, manage, and administer both men and women hockey laws. In the wake of the formation of Unified Men's and Women's Hockey Association in various states of Manipur under the principle of one game, one body, Hockey Manipur was formed an amalgamation of the joint meeting held on 28/6/2009, on 29/9/2009, and an ad hoc committee under the name of Hockey Manipur was constituted and constituted upon the formation of the ad hoc committee. The Manipur Hockey Association and Manipur Women Hockey are suspended from membership of the Manipur Olympic Association. The ad hoc committee was under the presumption that the Manipur Hockey Manipur was converted into Manipur Hockey upon its registrations with Registrar Society Manipur, bearing registration number so and so. Manipur Hockey was formed on 6/10/2009 without holding a general body meeting, and it has not fulfilled the required procedure and proper document. Thus, Manipur Hockey was registered on 12/11/2019 by some vested interest person which nullified and ulterior motive, and the same has been done with the process of amalgamations of Manipur and Manipur was pending. This is, my lord, completely a factual, my lord, finding by the Honorable High Court, Your Lordship. Upon amalgamation, the Manipur Women's Hockey Association, the hockey amalgamation was registered with the Registered Cooperative Society bearing number so and so, while the Manipur Hockey has been registered as a new society under Section 7(1) of Manipur Association Act. Hockey Manipur has been registered as amalgamated society. Challenging the process which was agreed, the Hockey Manipur filed the petition number 435/2010 before the Honorable Court, and by an order that the Honorable Court directed the Commissioner Government of Manipur dispose of the representation dated 4/1/2010 with a period of 2 months. Pursuant to the order dated 17/3/2016, the Principal Secretary issued an order dated 2/8/2016 directing Manipur Hockey and Hockey Manipur to reconcile and under a common banner within 6 months. Accordingly, on 1/7/2017, Deputy Secretary Corporation issued summons to the Manipur Hockey to appear on 10/7/2017 at 11 a.m. Challenging the summons, Manipur Hockey filed with petition number 562 of 2017 before this court, and by the order dated 19/12/2017, the audit petition was allowed, thereby passing the summons dated 1/7/2017. On 22/1/2018, the Secretary Government of Manipur passed an order directing the Manipur Hockey to change its name and alter its memorandum within 3 months from the date of receipt of this order. Agreed by the said order, Manipur Hockey filed with petition number 124 of 2018 before the Honorable Court, and by an order dated 27/11/2018, this Honorable Court, in an order to find out an amicable solution, directed the Registrar of the Society to examine and explore an amicable solution for having one associations only, for which Manipur Hockey was directed to appear before the Registrar. Accordingly, on 14/1/2019, the Registrar of Societies passed an order declaring the Manipur Hockey has violated the norms of registrations, and hence it is illegal. On 30/8/2019, the petition number 124/18 dismissed on the ground that the petition has no substance for the reason of non-joinder of necessary party. Accordingly, Hockey Manipur filed the petition number 724/2019 for implementation of order dated 22/1/2018 and later dated 14/1/2019. On the other hand, the case of Manipur Hockey is as follows. This is our facts again, my lord. Pursuant to the decision taken in the meeting held on 6/10/2009, after discussion and deliberation thoroughly on the issue and in view of the advice given by the IOA to the MOA to follow the policy of one game, one association, the members of the meeting resolved to form an association under the name and style of Manipur Hockey for not only uplifting the game of hockey in the state of Manipur, but also for the sake and interest of the players who are being deprived of their fruits of labor on account of the mismanagement by the members administrating the sport in the state of Manipur. After the formations of the Manipur Hockey, it approached Hockey India, which is apex body of the game in the country, for its affiliation with them. After taking into account this credential of the members of the Manipur Hockey who are managing the affairs of hockey in the state of Manipur granted appellation to Manipur Hockey to Hockey India with effect from 22/10/2009 of the President of Hockey India. In the said letter, Manipur Hockey was also requested to get itself registered under the Society Registration Act within 6 months and deposit the required appellation fee within 3 months from the date of said order. In terms of resolution taken in the meeting dated on 6/10/2009, necessary applications, documents, and registration fee required under the provision of Manipur Socialization Act 1989 and rules were submitted to Registrar Cooperative Society for registration of Manipur Hockey, my lord. My lord, just pausing for a minute, my lord. As I have, my lord, submitted earlier, Manipur Hockey, as soon as it has been formed, even for registration, we have approached Hockey India, and Hockey India has recognized us. That steps the respondent Hockey Manipur hasn't done till today. And we have been recognized by that, my lord, Manipur Olympic Association and IOC, my lord, Indian Olympic Association also, my lord.
Where's that recognition?
Yes, my lord. Yes, and it's, we have annexed. Based on Ghana. Page 92, your lordship. Page 92, my lord, from the President Hockey India. Further to your applications for affiliation to the Hockey India, we are pleased to inform you that you have been granted affiliation to Hockey India with effect from 22nd October 2009. And next page is, my lord, this is the notification of November 2009 by Registered Society, my lord, recognizing our registration, your lordship. Next page. This will notify the general information of Manipur Hockey having its registered address so and so and so and so or so and so so and so, my lord. Is. We have been given registration number also, your lordship. And the next page is certificate. And my lord, page number 115. One on five, your lordship, by the Manipur Olympic Association, my lord. Is hereby certified the Manipur Hockey bearing number so and so, registration number so and so, is an affiliated unit of the Manipur Olympic Association. Till today, my lord, Hockey Manipur has not been recognized by any of these, my lord, federations or any of these, my lord, so-called, your lordship, my lord, authorities to recognize hockey associations in the state, your lordship. And my lord, coming back to again 114. This is a letter from Hockey India, your lordship, to the government of Manipur, Director Youth Affairs Sports, recognizing us. This was 10th January 2011. 114. Recognition of Manipur Hockey headed by K.S. Thoiba Singh, Olympian. We are pleased to inform you that the Manipur Hockey headed by K.S. Thoiba Singh, Olympian, is the only recognized body of hockey India in Manipur state, which is affiliated to Hockey India. And Hockey India only consider the team players from the recognized state unit for the national champions, national coaching champs in preparation for the various national teams which represent the country. Teams for Manipur Hockey are eligible to participate in the men and women's national champions, from which selection committee choose the probables of national coaching camps, from which Indian teams are selected for various international tournaments. And we have been doing so, my lord. All the players who are representing India are from Manipur Hockey only, your lordship, till today. And by my lord, by coming to the conclusion of a wrong amalgamations, which never follow the rules, your lordship, if we have been deprived of, my lord, our recognition of registrations, then it will be very, my lord, it will be very injustice, very big injustice done to the hockey of Manipur, your lordship. Not only to the association, to the players who have received, my lord, medals and awards through Manipur Hockey only, your lordship. Then coming back to that, my lord, judgment, your lordship, page number 35, above 9. Pursuant to decision taken, the meeting held so and so. After discussing deliberately through on issues the view of the advice of OANRMA, the following policy was granted so and so. The members of the meeting resolved to form an association under the name and style of Manipur Hockey, not only to uplift the game of hockey in the state of Manipur, but also to set an interest of the players who are being deprived of their fruit of labor on account of mismanagement by the members administering the sport in the state of Manipur. Oh, I have read this already. The next page, your lordship. In terms of resolution taken, the meeting on 6/10/2009, necessary applications, documents, and registration fee required under the provisions of Manipur Society Act 1989 and rules were submitted to Registrar Cooperative Society for registration of Manipur Hockey. After completing all the formalities and procedures provided by law, Registrar had issued a notification bearing number so and so dated 12/11/2009, notifying the registration of Manipur Hockey under Section 7(1) of the Manipur Societies Registration Act. After registration, Manipur Hockey has been controlling, managing, and looking after the game of hockey as the only authorized and recognized associations by selecting the players to represent the state and arranging for their participation in various state level and national level hockey tournaments. Manipur Hockey is also organizing many national level, state level hockey tournaments right from its affiliations and registration till date, as it is the only authorized and recognized hockey associations in the state of Manipur. Only after registration of Manipur Hockey, the Hockey Manipur submitted applications for amalgamation of the Manipur Hockey Association, the Manipur Women's Hockey Association, into one unified body called Hockey Manipur, and also requesting for allowing the said amalgamation. After registration of Manipur Hockey, the Secretary of Manipur Hockey submitted the notification and certificate dated 12/11/2019 to the Secretary President Manipur Olympic Association for information and necessary action. The President of MOA issued an order dated 23/11/2009, revoking with immediate effect its earlier order constituting ad hoc committee to look after the affairs of hockey in Manipur. My lord, pausing for a moment, your lordship. When that federations have been wide enough and that Olympic Associations of India directed to have only one association, your lordship, at that point of time, my lord, that they have suspended all the associations and Manipur Olympic Association form an ad hoc committee to look after the affair of my lord hockey. Then, my lord, after the registration of this Manipur hockey, my lord, they wind up that ad hoc and handed over that my lord reins to us. Then we have been, my lord, running that show, my lord, till today also. Though there is no provision of filing an appeal, the president which where Manipur Hockey Women's Association filed an appeal before the Commissioner Secretary Register Society to set aside the registration granted in the favor of Manipur Hockey. During the pendency of the appeal, the registrar allowed the registration of the amalgamation society called Hockey Manipur by allotting registration number so and so by issuing a certificate dated 21/10/2010, hereby cancelling registration allotted to the Manipur Hockey Associations and Manipur Women Hockey Association with immediate effect. So, my lord, rightly or wrongly, my lord, even though there was no proper applications to the registrar by the so-called Manipur Hockey, your lordship, Hockey Manipur, sorry, my lord, the registrar has allowed for registration on the ground that is amalgamation of two associations, and they have, my lord, cancelled the registrations of the earlier two associations, my lord. So, my lord, on facts, by forgetting that earlier associations which has been dismantled and suspended, my lord, on facts, my lord, Manipur Hockey was the first association who have registered after the by that, my lord, policy of one game, one association comes, your lordship. In any case, your lordship, right or wrong, we is the first association. So, my lord, the honorable single bench, my lord, wrongly said that, we came later on and we should be, now name should be changed. Then the name should be changed, my lord, by assuming, but my not admitting that, my lord, okay, that amalgamation is process also correct. But to change the name of association and to modify that, my lord, the whatever association, the next association which comes later on has to do it. The first association who formed in the first stage, your lordship. During the pendency of the appeals when so hereby cancelling the session also challenging the Hockey Manipur file repetition number 435/2010. During the pendency of the said repetition, the Secretary General Hockey India wrote a letter dated 10/1/2011 to the Director Youth Affairs Sports Government of Manipur, informing the Manipur Hockey is the only recognized body of Hockey India in Manipur state, which is affiliated to Hockey India. On 4/3/2016, Secretary MOA issued certificate to the effect Manipur Hockey is the affiliated unit of MOA, my lord. These are all in our, my lord, favor, your lordship. Pursuant to the order dated 17/3/2016, passed in repetition number 435/2010, the Principal Secretary Corporation passed an order dated 2/8/2016, disposing of the appeal by giving an opportunity to the Manipur Hockey and Hockey Manipur to reconcile the issue. Thereafter, the President of Manipur Hockey wrote letter to the President Hockey Manipur inviting them for reconciliation and to unite the two hockey associations under the common banner. Since no response was forthcoming from Hockey Manipur, Manipur Hockey wrote a letter to the Secretary General MOA requesting for arranging an open discussion with the Hockey Manipur for merging of two hockey associations in the larger interests of the game of hockey and the players, your lordship. By going through this paragraph itself, my lord, by this time, my lord may be aware, my lord, how and where we stand. We always stand for the players, we stand for the sports, your lordship. We, one time, my lord, approached them also. Let's unite together for the sake of this hockey. Let's see, but how endowment they are, your lordship. The conduct of this other association. We are ready to sacrifice as by uniting as one. We are not formed this association for my personal benefit. For the benefit of this player, which for the state of Manipur, which is being called as a powerhouse of sports in the state of in Indian state, your lordship. We have done this. We have even approached them from our own, without any directions from any authorities, your lordship. It is ever that instead of making an effort for the reconciliations and merging, the Hockey Association filed another representation dated 12/4/2007 to state government praying for cancellation of registration of Manipur Hockey on the same ground taken in the appeal dated 4/1/2000. But again, my lord, they keep on giving representation to representations to cancel it. At the same time, we keep on approaching them, let's form united, my lord, associations. This is what the conduct of these two associations, your lordship. And without giving an opportunity to the Manipur Hockey, the Principal Secretary Corporation issued an order dated 22/5/2017, cancelling registration of Manipur Hockey with immediate effect and also notifying the Hockey Manipur is recognized as a sole and genuine state-level association for hockey game in the state of Manipur. See, my lord, my registration was cancelled by the Principal Secretary Corporation and saying that this the other one is the only association for the state government for the game of hockey without any authority, my lord. They are not the authority to, my lord, to decide it, who is the association for that. They have the only authority to see that a registration has been done properly or not as per rules. Then, my lord, as we have demonstrated earlier, my lord, by giving a representation to the minister and by the direction of the minister, as everything has been done, my lord, by seeing this type of actions from the authorities, my lord, it's very clear that, you know, lots of political pressure is there against us. Against us, the association who is fighting for the game of hockey, your lordship, in the state of Manipur and overall in the state of India, your lordship. Agreed by the order dated 22/5/2017, Manipur Hockey filed repetition number 391 for passing the said order of cancellation, your lordship. During the pendency of said repetition, the Principal Secretary issued an order dated 14/6/2007, withdrawing the order dated 25/2017. They have withdrawn, my lord, after we filed the petition, my lord, they have withdrawn the cancellation of the registration, your lordship. Just after the withdrawal dated 14/6/2017, the Hockey Manipur again for the third time filed another representation 27/6/2017 to the Principal Secretary praying for cancellations of the registration of Manipur Hockey. Where the Deputy Secretary issued summon dated 1/7/2017, challenging the summon Manipur Hockey challenging the summon Manipur Hockey filed in petition number 562 of 2017, and by order dated 19/12/2017, the said petition was allowed. After the disposal of the writ petition, Manipur Hockey filed another application dated 29/12/2017 to the concerned authorities of the state requesting them for directing Hockey Manipur to change its name by invoking section 11 as its name is exactly similar to the name of already registered Society of Manipur Hockey. In fact, my lord, we are always the first one who always take the steps. Even changing of the name, we have taken the steps first. But today, on the contrary, like my lord, we have to suffer for taking up the steps as per rules, as per law, your lordship. According to Manipur Hockey, there are only body affiliated to recognized by the Hockey India and MOA for the sports of hockey in the state of Manipur, which had conducted many tournaments, coaching camps in different levels in the state of Manipur. Instead of considering the applications dated 2019-2017 after a delay of more than 8 years from the date of registration, my lord, as we have, my lord, submitted earlier, there was a huge delay of more than 8 years in cancelling my registration, your lordship. And my lord, and saying that my name should be, my lord, changed and my member association should be modified.
That was withdrawn, isn't it?
Yes, my lord.
That was withdrawn.
No, my lord. Later on, my lord, this is the impugned order 22/1/2018 is the impugned order before the single bench. And accordingly, my lord, today we are before you as a date of appeal. 22/1/2018 again says directed to change our name and modify our member association, my lord, after 8 years. Whereby the Manipur Hockey was directed to change its name within 3 months on the ground that at the time when the Manipur Hockey was registered on 12/11/2009, there were 2 associations existing which is alleged to be clear violations of Section 10 of the Act. Agreed by the order dated 22/1/2018, Manipur Hockey filed petition number 124 of 2018, and the said petition was dismissed on the ground of non-joinder of necessary party. However, this court has granted liberty to Manipur Hockey to approach any forum, including this court, for redressal of these grievances according to law by order dated 30/8/2019. Hereafter, Manipur Hockey filed petition number 916/2019 and set aside order and to set aside the order dated 22/1/2018, my lord. This is the last petition, my lord, against whom we have filed this appeal. And Mr. Hemchand, the London Council for the Hockey Manipur submitted that upon amalgamation of Men's and Women's Hockey Association, Hockey Manipur was registered with the Registered Cooperative Society, while Hockey Manipur has been registered as a new society under Sub-1 of Manipur. So, according to London Council, Hockey has been registered an amalgamation society under Section 12 of the Act, my lord. So, my lord, my humble submission is this, your lordship. If that association, new association has to be formed, by the amalgamation of 2 associations as allowed by this Section 12 of this society, Act, your lordship, then, my lord, this should be follow the rules. But till today, they haven't filed any application to register as per the Act which we have shown to your lordship. They have to give a proper application to the registrar. After their registrar has to, my lord, then take this 3/5 of this, my lord, of the members of the associations. It was never done. All that they have done was giving a representation to the minister. And the minister has role, my lord, even though however big he may be chief minister also, but my lord, the rule has to be followed. Until unless they file a proper application to the registrar, my lord, this amalgamation process never happened. Even this is null and void. This is null and void, your lordship. This is null and void. Till today, they haven't done it. And in the RTI report itself, it says that there is no record of general body meeting, no record of my lord meetings yearly wise, and no record of this, my lord, of office bearers year wise. Nothing is there, your lordship. So, in short, my lord, yeah, and 3P membership approval was not done as per clause number 2 of Section 12. This is all compulsory administrative provisions, and my lord, nothing has been done, your lordship, till today. And my lord, wrongly the single bench has come to the conclusion that is amalgamated has been done. Then, my lord, the wrong cannot be, my lord, professionally cannot be allowed, my lordship, by this honorable court. That's why, my lord, all that I was praying is just remand it back, let the matter be heard on merit, including amalgamation. I'm not asking something which is not like the learned, my learned dear friends appearing for the learned opposite party, with something which they should not be allowed. They can easily defend their case if they are completely, they have done it as per rules, your lordship. Then, my lord, the next para. The learned senior counsel for the submitted that without following the procedure as laid down under Rule 13 of the Manipur Society Registration Rules, so the rules so Manipur Hockey was registered by the authority. In fact, no publication calling for any such objection was made at any point of time. At the registration of Manipur Hockey Association, Manipur Women Hockey were registered and their registration was cancelled. Yeah. The Learned Senior Council urged that the wake of the formations of the Unified Men's and Women's Hockey Associations in various states of the country under the principle of one game, one body. Hockey Manipur was formed by the amalgamation of two registered associations into one Unified Hockey Association in the meeting held on 28/6/2009. When the process of amalgamation was underway, some interested persons registered Hockey Manipur. He would submit the being agreed by the registration of Manipur Hockey Manipur submitted representation so and so to the authority. This is completely wrong statement, your lordship. If they are saying that, my lord, just by the to unify and having a my lord one association by the amalgamation of the two associations, my lord, and the process is underway. By sitting together for a meeting in some place, my lord, taking a resolution doesn't mean that, we have started the process. For the registrations of an associations, the process is what? Just what I'm asking myself also, is to act according to the process as per the act and rules. By not moving that any, my lord, actions as per the acts and rules, by sitting together, having hundreds of meetings together, having a cup of tea, my lord, it won't help. If they really want to have this from the association register it, my lord, they have to act according to the act and rules, which they haven't done till today, your lordship. So, my lord, may I proceed again, my lord? The Learned Senior Council next submitted that the pursuant to the order dated 17/3/2016, the Principal Secretary exercising the power conferred under Rule 38 of the Rules of 2004 has given an opposition to the Manipur Hockey and Hockey Manipur to reconcile and some under the common banner within 6 months in the best interest of the hockey game and players. According to the Deputy Secretary issued summons on 7/7/2017 challenging the summons dated 1/7/2017 Manipur Hockey file read petition number 562 of 2017 because the Honorable Court by the order dated 19/12/2017, the said read petition was allowed. While allowing the petition, the court observed that it is open to the state government to proceed in accordance with law as regard the registration of society pertaining to hockey sports in Manipur, keeping in mind also circumstances. So, my lord, even the court directed that the state government to proceed in accordance with law as regard to registrations of society. But the other associations, my lord, they haven't done anything as per the rules. And my lord, another humble submission is your lordship. Manipur Hockey, all the office bearers, they are all international players, maximum of them, your lordship. All the international players who have represented India, who represented Manipur, they are with us. And my lord, thinking about, let's forget everything for the time being, my lordship. Thinking about in the interest of the hockey, of the game, your lordship, the players who have represented India, who are really contributed their life and energy for this game, your lordship, and some persons who have acted, I cannot blame anybody, but some persons who have other motives want to run an association, what is more important? And who is going to take care of the hockey, your lordship, in the state of Manipur? That's what I'm asking myself, your lordship.
These are all his submission on it. Let us go to the findings.
Yes, man. No, my lord, I just wanted to read it out, your lordship. I will come to that. Saying that, my lord, the facts which I have roughly, my lord, submitted just one by one. I just wanted to point out. By this time, I think I have pointed out enough, my lord, facts which may have, can demonstrate to the honorable court that, my lord, we have done anything wrong. We always, my lord, stand for the hockey game in Manipur, my lord. We are fighting for that, your lordship. May I read it out? Just 13, 14 people. The Mr. S. Paunam was appearing for us, my lord, in single bench. His submission, my lord, just few lines, your lordship. Para 13. Selling the important Indian order 21 to 18, Mr. S. Paunam, the Senate Council for the Manipur Hockey, submitted that the first respondent is an arbitrary and malified manner in colorable exercise of power with an ulterior and preconceived motive to cancel registration of Manipur Hockey has passed the aforesaid order that too after more than 8 years after the Manipur Hockey Association and Manipur Women's Hockey Association have ceased to exist with effect from 29/6/2009. And the order amalgamation of the said two society were issued with effect from 21/1/2010. On the aforesaid ground itself, the impugned order dated 22/1/2018 deserves to pass. The Senate Council further submitted that the registration of hockey Manipur was allowed only on to 21/1/2010, much later than the registration of Manipur Hockey, which was allowed on 12/11/2009. In view of such undisputed facts, invocations of the provisions of Section 11 of the Act of 1989 and Rule of 14 of Clause 9 of the Rules 2004 by the first respondent against Manipur Hockey is totally ignoring the application dated 29/12/2017 submitted by Manipur Hockey, which would submit the impugned order dated 22/1/2018 has been passed illegally without any authority of law. The Senate Council then submitted that the order dated 22/1/2018 has been issued with malified intention to scuttle the promotion, propagations, and development of the sports of hockey in the state of Manipur, in which Manipur Hockey has been and is deeply engrossed with, as will be shown by the facts that because of this credential, it is the only recognized body for the sports of hockey in the state of Manipur by Hockey India, which is the apex body for the sports of hockey in the country and has been conducting championships in the state of Manipur. In fact, the first respondent issued the impugned order dated 21/18 at the instance and dictation of Hockey Manipur. The Central Councils for the Manipur Hockey urged that the first respondent for the matter, the second respondent has not taken any action against the Hockey Manipur for changing the name of the association or cancellation of their registration, knowing fully well that the same is a defunct society existing only in paper and not engaging in any activity or activities worth its name commensurate with its aim and object for which it has set up and shall be registered and renewing its registration in connivance amongst the respondents on the basis of the false and concocted documents. This is respondent number 1 and 2 stopped by their conduct from issuing the impugned order, and therefore interference of this court is very much frequent. So, my lord, my humble submission is, your lordship, as rightly pointed out by the Council for the Hockey Manipur Hockey in that before the single bench, your lordship, the actions of the state government is completely arbitrary and malified. Even though we are the first association which has been formed as per rules, by directing us to change our name and to modify our, my lord, member associations, by completely neglecting, your lordship, in what process the amalgamation has been done, then, my lord, injustice is completely done to us, your lordship. That's why we are before this honorable court, your lord. Then, my lord, kindly come to para number 44. To have the wrong factual conclusions and to highlight it. It's wrong. Starting from internal page 39, your lordship, page number 44. Running page 35/40, internet page 39. Of that, my lord, improving judgment. Para 44, your lordship. May I read out, your lordship? In fact, Manipur Hockey Register, the section 7(1), clause 1 of the Act, whereas Hockey Manipur is amalgamated society registered under section 12 of the Act. For already reference section 7 and 12 of the Act are quoted there. 7, register upon being satisfied that the memorandum and the regulation accompanying it comply with the requirements of this Act and rules upon payment of the fee referred to in subsection 2 shall certify under this hand and seal that the society is registered under this Act. There shall be paid to the registrar for the registration of the society under this Act a fee of 100 rupees or such similar so and so, and appeal shall lie to the state government, my lord. Then 12 also, my lord, as I pointed out, whenever 2 or more societies desire to amalgamate, the governing body of each such society shall submit a joint proposal in writing to the registrar for his prior approval thereto. No such proposal shall effect unless the proposal with the modification of any suggested by the registrar is confirmed by 3/5 of the joint members of the society council. This is also mandatory, your lordship. And all these things, my lord, the last para, thus it is clear that whenever 2 or more societies desire to amalgamate, the governing body of its such society shall submit a joint proposal in writing to the registrar for his prior approval. In the case on hand, Hockey Manipur has fulfilled the provision of section 12 of Act of 1989, accordingly go register. It's completely wrong factual conclusion, my lord. They have never done this. That's why, my lord, we are before your honorable court, before this honorable division bench, and all that I'm praying is to consider all these factual facts. It should be demand back again, your lordship. As we have challenged by filing another petition also, your lordship, demanding the amalgamation, your lordship. It was never done as per the rules and as per the Act, your lordship. But with great respect, your lordship, the London single judge might wrongly come to the conclusion that it has been done as per section 12 without going through those documents, your lordship. And at the point of time, my lord, after filing the RTA only, we got those documents. Yeah. Then, my lord, para 55. And para 55, your lordship. May I read out also? Countering the said submission, the Learned Senior Council for the Hockey Manipur submitted that many members of the Hockey Manipur have been participating in various national and international level matches. Nothing has been produced by the Hockey Manipur to show the Hockey Manipur is existing in paper only, and no activities are undertaken by them, your lords. This also, my lord, today we have enough documents to counter this. That's why, my lord, we have filed this additional document affidavit before your lordship. It's on record today, your lordship. Then, my lord, para 58. Due to the existence of Hockey Manipur, no. Yes, my lord, I will skip this, my lord. I'll come next page, your lordship. The first paragraph. Second, this court is of the view that such a conclusion arrived at by the secretary coordination it should be cooperation, your lordship. Is based on in-depth examinations and considerations of the substantive points put forward by both the parties, and also taking into consideration that both Hockey Manipur and Manipur Hockey have committed and produced many of the prayers. So, my lord, the honorable single bench, with respect, your lordship, come to the conclusion that he has examined depth and considered all the substantive points regarding these amalgamations and everything, your lordship. It is factually wrong. because the inquiry report, which I have read out in the beginning of laws, it clearly says that by the time they have, my lord, taken decision to register our society, by the time that Hockey Manipur hasn't filed any applications, they haven't filed any documents to the authorities for the registration, your lordship. So, my lord, yes, I have submitted, my lord, they haven't taken any steps for the registrations. Yes, they might have sit together for meetings. That's different story, your lordship. Yes, ma'am. Yes. And writing something in the minutes of the meeting, my lord, without moving forward as per rules and act, your lordship, there's no meaning as such, your lordship. That's why, my lord, time and again, your lordship, at the cost of repetitions, your lordship, I have been submitting to your lordship that this is a fit case to remand back to consider all these aspects in the interest of justice, your lordship. Otherwise, my lord, even my writ petition, which is pending today, challenge amalgamation, any order passed by this honorable court may affect it, your lordship. Even though we have challenged the amalgamation as per rules. So, my lord, to solve the problem completely in one go, my lord, by seeing all this, my lord, documents, your lordship, my lord can remand it back. And I think my learned friends, they should not shy away from contesting it. We are ready to, my lord, contest this, your lordship, as per the documents available today. If the honorable court thinks that, my lord, that I'm correct, you can allow my repetition. Or if they think that I'm wrong, that's as per the documents available, they can dismiss my repetition, your lordship. They can decide this way, that way, your lordship. It is for the wisdom of the honorable court. But the honorable court should, my lord, hear all the pleading, they should examine all the documents minutely to decide the amalgamation process, my lord. This is my humble submission, your lordship. Let me, my lord, read again, your lordships. Kindly see this. Huh? And the last one, my lord, the directions of this honorable court, single bench, your lordship, page 35 by 54. In the reason, writ petition 916 of 2019, my writ petition is dismissed. Writ petition 724 of 2019 allowed their writ petition. The respondent number 1 and 2 are directed to implement, execute the order dated 22/1/2018 passed by the Secretary Corporation, Government of Manipur, and later dated so and so, issued by the Registered Society within a period of 2 months from the date of receipt. State government so and so dismissed, my lord. So it means, my lord, meaning hereby, my lord, by giving me 3 months time to change my name and to modify my my lord, my memorial associations, your lordship. Memorial associations which we have taken and we have been following till today in letter spirit, my lord, defending and protecting and, my lord, promoting this game hockey instead of Manipur. Now today, we have to amend it. Then we will be nothing, my lord. We will be some other associations and associations formed by the international players of hockey. They will be my lord, associations of some other purpose, not for the game. So all that we are praying, your lordship, is, my lord, kindly remand this matter. Let it be heard together, along with the particular petitions, by, my lord, examining that, my lord, the issue of these amalgamations and whether it has been done properly or not.
What is rule 13?
Yes, your lordship.
Rule 13.
Rule 13. Yes, okay. Ah. Then. Later. Let me check it a bit. I remember we forgot. No, then you want to tell what's it.
Similar and identical name to the association may not. It is the procedure of the rule. Procedure of the rule 10 method. Section 10.
Auto regulation thôi, nó đi không? Yeah, me. Regulation. But why not as per Manipur Society's regulations, your lordship, rule 13 is power of function of general body, your lordship.
That is under the act. This is rule 2004.
2004. My friends.
Or 13, my lord. Similar or nearly similar names and identifications under section 10 is, my lord, connected with logistics, my lord. When an application for registration is received, it shall be examined in the office of registrar of society whether societies or similar or nearly similar names have already been registered in the office. Other books of record which may give a clue to this and shall also be checked up, and the same process shall be done when a proposal or decision of the change of name of societies in the district, your lordship. This is the rule 13, your lordship. So, my lord, my humble submission is this, your lordship.
You read it down.
Yes, my lord.
The next para.
Before registration and change of name, publication shall be made by the society in the widely circulated local newspaper. Invite objection to register under the name and change of the name. Objection shall be submitted within 15 days from the date of publication of registered societies. My lord, we have published in the newspaper before we filed for the registration, your lordship. This we have done. No objection came. We have done it. This we have done it, my lord.
Just take up para 48 of the judge.
What is it? The Learned Council for Registrar submitted as per the report of the Registrar Society. Only 5 days were given after the advertisement registration of Manipur Hockey before registration was done. Therefore, as rightly argued by the Learned Council for the hockey, registration of hockey was done in violation of 13 of the rules, your lordship. Then, my lord, if this is that point, my lord, to be decided against me, then, my lord, then the various, the serious, my lord, irregularities regarding the hockey Manipur, my lord, because they never apply any for registration.
No, that is one part.
Yes,
That is one part.
yes, ma'am.
The other part we also.
Other part, we have done it, except this, my lord, except this point that, 15 days, some days are lesser. Instead of 15 days, 5 days was given for objections. This is the only irregularity, your lordship. But my lord, inquiries was done by the register, by the inspector. Cooperative Society, your lordship. 97, 28. My lord, writ appeal 28, page 114. It's not that we file and they have done it like this, your lordship. We have already pointed out, your lordship, page number 118. I will read the whole, my lord, inquiry report. I will read the whole inquiry report, Your Lordship. Starting from page 117 of writ appeal 28. This is an inquiry done by the authority only. Yes, my lord. And my lord, it's not that, my lord, the issue is not that, I have been registered wrongly. It was never an issue. They have said that you have registered, but name is similar, you should change it. That's the thing. Your Lordship. Yeah. Yeah.
There's any date lordship convenient to your lordship, any date.
Lordship, no problem, because your lordship had directed them to implement the SOP.
Item 6 on request made by the parties. When do you want? Give a date.
7th February, Lordship, if it is convenient.
7, we'll have it on 12.
Lordship.
Lordship, one difficulty, my lord. 12th, I will not be in station.
Okay.
Any other date?
16th?
Yes, Lordship. Deeply obliged, Lordship.
Thank you, sir.
So, my lord. So, my lord, let me take your lordship again to the inquiry report, my lord. Because, my lord, my registration was not done, just a mere filing of this application to the association authority, your lordship. The authority have done a detailed inquiry, your lordship. Then they allowed my registration, your lordship. Let me take again to the other writ appeal 28. This the report we haven't
In the
filed.
first place, when was the paper publication done?
No. Well, we'll just come back to my lord. We'll find out. My junior will find out. There we go. No. No. No.
One,
112. My lord, page number 112. Retype, my lord. English translation 113. 112 is Manipuri, my lord. 2310 2009.
Read appeal number?
Read appeal number, my lord, 28 of 2023.
The report.
Yes, my lord. No, yes. No, my lord.
Read the appeal, my lord, 28 of 2023,
23
filed by me.
page-
Filed by me.
No, this, my lord, this is read appeal. We have annexed this to read appeal number 28 2023, your lordship. Page number 112. It's Manipuri the newspaper. So my lord, English translation is page number 113. The previous page 112, my lord, is Manipur. We have this is a unique education. Just above that is the notification, your lordship. Next is the with aim for developing hockey in Manipur in the application of Manipur hockey form. Those who are interested may kindly inform report within 5 days.
It is not in the form of.
So, my lord, coming back to this inquiry report. After we filed, my lord, the inquiry was done by the authority. The difference between these two associations is this, my lord. We did it. Maybe there is one equality here regarding the days, but inquiry was done and then they allowed us. It was not in the other case, your lordship. Till today, they haven't applied. Inquiry report is, my lord, properly type is, my lord, 117. Page number, same, paper book. May I read out also? Inquiry report of Shri Tri Pradeep Kumar Singh, Inspector CS, into the matter for registration of the proposed Manipur hockey submitted to Registrar of Society Manipur. In pursuance with order number so and so dated 6 November 2009, I have conducted into the proposal for registration of the Manipur hockey under MSR Act 1989. In this regard, I contact Sri W. Herojit Singh, General Secretary of this proposed association, and his residence is Larik Yambam Leka, Imphal. It's on 9/11/2009 at his residence. The proposed association was formed on 6/11/2009 at Hotel Nirmala with Sarbashri K. Devakanta Sharma and Anand Prakash, IGP, in the presidium. 39 representatives of the various associations attended the meeting. As for the proceeding of the meeting shown to me, which has also been submitted to the Registrar of Societies Manipur by the proposed association by letter number so and so dated 17/10/2009 with the request for registrations of associations. We have done it properly, Lordship. In the meeting, the following members of the proposed association were elected managing committee member and office bearers. K.S. Thoiba, he is, my lord, an Olympian. Famous Olympian, my lord, he is the hockey player himself. And Nilakamal, he is also, my lord, Olympian hockey. He is, my lord, first Olympian, my lord, of the state, my lord. Tej Samu, Sobita, Koilemba, Heroji, Ramesh, Nandeso, Sunita, Nirmalata, Tiken also, my lord. And Bimol, Komol, all this, my lord, we can skip this, my lord. Tiken also, my lord, as an international player. Association submitted a list of 34 members to register Society Manipur on 17/10/2009. Their particulars have been given in the list. Photos have also been pasted. The president and secretary and the treasurer have indicated the member list. Memorandum Association regulation were also submitted. The main object of the association is to promote the game of hockey in Manipur. The regulations are also framed according to the provisions of MSR Act 1989. Hence, the memorandum and registrations are found in order. Proposal for registration is objected by another proposed association, namely Hockey Manipur, said to be formed by the amalgamation of Manipur Hockey Association, registration number so and so, Manipur Hockey Women's Association number so and so, according to a direction of the Indian Hockey Olympic Association as per instruction of the International Hockey Federation, World Hockey. Sri Manihar Singh, Secretary of the proposed Hockey Manipur, submitted his objection to Registrar of Society Manipur by letter number so and so, dated 13/10/2009. He further objected the proposal of registration by submitting to Registrar of Society, namely so and so. No resolutions, memorandum association regulations, and member lists of the proposed hockey association, proposed Hockey Manipur are not submitted. Only 2 objection letters are achieved from them. This should be received, my lord, by a printing mistake, or lordship, typographical mistake. In this regard, the Manipur Olympic Association has given their no objection certificate to the registration of the proposed Manipur hockey, of which Sri K.S. Thoiba Singh and W. Herojit are the President and General Secretary, respectively. The YAS, Department of Sports, my lord, Youth Affairs and Sports Department, has not yet given no objection certificate with referring to the registration of Society Manipur so and so 6/9/2007. In fact, the amalgamation of the Manipur Hockey Association and Manipur Women's Hockey Association was interested by the Indian Hockey Association by letter number so and so to the Manipur Olympic Association. An arrangement arrived at this joint meeting of the representative of the Manipur Hockey Association, Manipur Women's Hockey Association, and the Manipur Olympic Association in the joint meeting held on 29/6/2009. An association in the name of Hockey Manipur was constituted on that day. In the meeting, the ad hoc committee constituted of the following office bearer, educators, so and so were formed. Here, in that my lord ad hoc committee, Mr. Thoiba was also there, your lordship. Our president, your lordship. Nilakamal also there, Lord. Tikian also there, your lordship. They are all our members, your lordship. Consequent to the formation of the ad hoc committee, the Manipur Hockey Association and Manipur Women's Hockey Association was suspended from the membership of the Manipur Olympic Association. In this regard, MOA issued an order number so and so dated 29 June 2009. A copy of the order was submitted to IOA Yas Manipur Registrar of Society, Manipur, Manipur Hockey Association, Manipur Women's Hockey Association, etc. Copy of the order are also given to the editor, ISTB DDK Info, local newspaper, also for publications. Section 10 of the Manipur Legislative Society, DIBA registration of two similar or nearly similar associations. It has been stated that stated above, the complete proposal of registration has been received from the Manipur Hockey, while no such proposal has been received from Hockey Manipur. Registering authorities now to decide whether the proposal registration of the Hockey Manipur Hockey will be considered or not for registration. The registration of the Hockey Manipur is not considerable at the present stage, as complete proposal has not been submitted by the party or lawsuit. After this, my lord, inquiry report, they allowed us, and in between, my lord, as we
There
have.
was an objection against your registration.
Yes, my lord. In fact, what happened is this, my lord, instead of applying for their registration, they are just objecting on registration only. That's the
So
issue.
what happens as per the rules of the act? If
Yes.
there's an objection, what is the procedure?
My lord, it is silent regarding that, I think. But my lord, the inquiry report satisfy, my lord, the registrar authority, office of the registrar authority is satisfied with the inquiry report. They have allowed us, my lord. It's not as simply we applied and they allowed us. They have done the inquiry. In inquiry also, they have said that there was objection, but the person who's objecting, they never filed any application to the registrar for their registration, your lordship, by just mere objection. The objection can be raised by many people, but without taking, my lord, the proper, my lord, procedure. So, my lord, my humble submission today is, your lordship. Even, my lord, regarding this section. My lord, my humble submission is this, lordship. As per the act, my lord, even though, my lord, today the authority is saying that, directing to change our name as per the section 10 of the Society Registration Act, your lordship, and directing to modify our, my lord, section 11, 10 and 11. The directed, to us, my lord, to notify our member associations, your lordship. Until unless, my lord, the other association, which is claimed to have a similar name, it has not been registered as per the rules. Like, my lord, amalgamation of two associations, which was never done as per the rules, my lord. There is no questions of me, my lord, barring my having this name and, and directing me to change my lord, member associations, because, my lord, the other association is not registered properly. And the inquiry report speaks loudly, was said that they never submitted no proposal, my lord. The only, my lord, proposal was a representation to the minister, not to the authority or lordship. And in the situations, my lord, minister is not authority. He may be minister, but he's not authority or lordship. So, my lord, all that I am praying is this, lordship. Because of all this confusion factual fact and wrong factual facts, my lord, come to the conclusion by the learned single bench, your lordship. And apart from the fact that there is another writ petition challenging the amalgamations of this private respondent in before the single bench, all that I am praying is, lord, my lord, can my lord cause this judgment and remand it back, set aside this judgment, remand it back, your lordship, to hear afresh. I am not saying that closed the issue completely in my favor. I am not saying that also, your lordship. Cause it, remand it back to hear it afresh with the amalgamation issues, along with the other writ petitions, and decide the matter for good permanently, your lordship. That's my humble submission, your lordship. I am not praying that it should be allowed in my favor completely, that I should take that benefit of that. I'm not that. I want to be fair, Your Lordship. Fairly, I'm just, my lord, submitting to the Honorable Court is this.
Acha, Hockey Manipur is now a registered society.
Yes, Hockey, no, is a registered society, but Hockey Manipur is not affiliated to any of Indian Olympic Association, Hockey India, nothing. They are not. I am the one who is being recognized till today, my lord. I am the one who is, my lord, arranging that, my lord, running the show. I am the one who is arranging, my lord, these tournaments and everything. I am the one who is sending the players for participation. Representing India also, my lord. And all the local clubs affiliated to us, obviously, my lord, we are the only person recognized by the Hockey India and Olympic associations, both Indian Olympic Association and Manipur Olympic Associations. Those, my lord, I am the only one, my lord. So all that I am praying is, my lord, I am not praying that allow this writ appeal and my name should be registered, their name should be cancelled. No, I'm not saying that. Also. Very fairly, I want to remand it back. Hear it afresh again, my lord, with these amalgamation issues.
You are registered on Manipur Hockey?
12/11/2009. And the impugn order was passed after 8 years.
And Hockey Manipur?
Registration, my lord, it is not the
21/1/2000.
registration, it is the allotment of the number.
Hockey Manipur
Different
is,
sections.
no, Hockey Manipur is, my lord, 21/1/2010. And when we received the registration number,
21?
21/1/2010. After a few months, Your Lordship. And my lord, on the day we received the registration number, by allowing a registration, my lord, there was no association as such in that name, except those two defunct, already suspended associations, Manipur Hockey, Women's Hockey Associations, Manipur Hockey Association, which was completely, my lord, suspended later on, my lord, these things. Okay, don't get mine.
This, what you call this, Manipur Hockey Association
And Manipur Women's Association, Hockey
they were
Association,
disbanded.
disbanded
By which order?
by Manipur Olympic Association. Mhm.
If you also look at it, 108 and 109, my lord. It is very clear.
108.
108 and 109, my lord.
Of writ
Of the writ appeal number 27 of 2022, on which you respect me. Now, my lord, 108, your lordship. It is hereby certified that pursuant to section 12, the lordship, their registration is under section 7 of the Manipur Society Registration 1999. The society hitherto called Manipur Women Hockey Association, register number 1994 of 1976, dated 23rd October 1976, and Manipur Hockey Association, register number 2002 1976, dated the 26th October 19, have been amalgamated into one society in the name of the Hockey Manipur, Kumalam Park, Imphal East, with reference to the proceeding of the joint general meeting of two associations held on 18 October 2009. Registration number 21 January has been allotted. My lord, under section 12. Read which rule? Rule 15, my lord. And given under my, it was on 21st January 2010. Then thereafter, my lord, a very important thing is that 109. 109. If Lordship look at very carefully, my lord, Lordship may find 21st January 2010, same day. What it talks about, consequent on the amalgamation of the Manipur Women Hockey Association, register number so-and-so 23rd October 1976, and Manipur Hockey Association, register number 1976, dated 26th under Section 12 of the Manipur Society Registration Act 1989, forming a new association in the name of the Hockey Manipur, Human Lampak, Imphal, to which registration number is 419 MSR 2010 dated 21st January 2010 has been allotted.
69,
Online Palmay Register of the Society Manipur exercise of the power conferred under Section 12B of the Manipur Society Registration, read with Rule 15(8) of the Society Registration Act, hereby cancelled. Now, these two associations has been cancelled. The registration number allotted to the aforesaid two with immediate effect, meaning thereby 21st January 2010. These two associations is very much exist.
So, my lord, let me come to my lord, page 69.
Sir,
One more organization, right?
here,
The page 69, my lord,
of
writ appeal 27. Page 69, R4. How it started, your lordship?
1 minute.
Mm.
Yes.
This affiliate, the President, Secretary, State Olympic Association is from the Indian Olympic Association, your lordship. This affiliation of Indian Hockey Federations and Indian Women Hockey Federation and provisional affiliation to Hockey India. How, my lord, Indian Hockey Federations, both men's and women's have been, my lord, disaffiliated. Then the said Manipur Hockey Associations and Manipur Women Hockey Association were affiliated to this. It is, and these federations are gone in debt, your lordship, by this letter. As you are aware, the Central Assembly of the Indian Olympic Association is its meeting held on Pune, October 10, 2028, has constituted a 9-member committee vested with all the power of general body to deal with the issues related to the hockey activities in India. As per the decision of the 9-member committee, the Indian Hockey Federation of Indian Women's Hockey Federation have been disaffiliated. The recognized and provisional affiliation has been given to one association, India Hockey India, and to look after the affairs of hockey in India for both men and women. Hockey India shall work on one game, one body principle, and shall give recognition to one body in each state and union territory to control, manage, and administer both men and women hockey. You are thereby advised to work in this direction and ensure affiliation recognition of a single association in your state to look after the hockey activities for both men and women. Then, my lord, Yes, 75. Then, my lord, page 75, your lordship. Manipur Olympic Association. 29 June 2009. R7, your lordship. Order dated 29 June 2009, as instructed by the Indian Olympic Association, India dated letter dated 1st June 2009, and agreed in the joint meeting of the representative of the Manipur Hockey Association, Manipur Women Hockey Association, and the Indian Olympic Association held on 29 June 2009. I do hereby constituted as ad hoc committee with the following members under the name of Hockey Manipur, so and so, so and so. The committee will also finalize constitute Hockey Manipur and arrange conduct election of its bearers for member of executive committee, hockey, etc. And this, and consequent upon the formation of the ad hoc committee, the Manipur Hockey Association or Manipur Women's Association are suspended from the membership of the Manipur Women Association, Olympic Association, your lordship. Later on, my lord, Manipur, next page, on the 1st day in 2009, Manipur hockey was formed. As I had pointed out by chaired by two Olympians, my lord, page 76. You are cordially invited to attend the meeting, discuss the following important agenda to be held on 6 October 2009, Hotel Nirmala, so and so. Present scenario Manipur Hockey, so and so, Your Lordship. Type copy is page number 81, Your Lordship. Page 81. As directed by the Indian Olympic Association, the Manipur Hockey Association, Manipur Women's Hockey Association have been de-affiliated by the Manipur Olympic Association after constituting ad hoc body of Manipur Olympic Association to look after the hockey activities for men and women in the state. At the same time, due to the intervention of the court, the activities of the hockey in Manipur came to a halt, thereby causing inconvenience to the probable players of the state and even in organizing different tournaments in the state. The circumstances aroused have been very unfortunate. And the Manipur team has been debarred from participating in national championship. In order to bring a settlement this issue, representatives of the affiliated hockey hockey bodies of Manipur, sympathizers, members of the previous hockey associations held a meeting on 6 October 2009 at the conference hall of the Hotel Nirmala, MG Avenue, Imphal, and discussed the whole issues under the convenership of hockey Olympian Shri K.S. Thoiba and P. Nilakamal Singh, who had been closely monitoring the hockey scenario in Manipur. After a thorough discussion, the members present resolved to form Manipur Hockey comprising of 21 executives, my lord. That's how this will form, my lord. But, my lord, in short, my lord, my humble submission for the kind considered honorable court is this, lordship. In any case, my lord, the formations of Hockey Manipur by the process of amalgamation of two former associations was never done as per rules, and they never till today they haven't applied for that amalgamations in the proper procedure following the rules and act. And at the same time, my lord, the formations of Hockey Manipur by following the procedure, except that the number of days lesser in giving advertisement notice, except that also was done away by the my lord inquiry committee of the authority, allowed for the registration of this Hockey Manipur far before the formation of this Hockey Manipur, your lordship. So, my lord, in any case, my lord, even my lord, considering whether my name should be changed or not as per the rules, as per rule date 11 and everything, your lordship, doesn't arise, my lord, until unless that the amalgamation was done properly as per section 12. And that has to be decided first whether the amalgamation has been done or not. Otherwise, my lord, there was no amalgamation, then there is no, then the order of this, my lord, state government, registrar of the state government to change my name is completely, my lord, uncalled for, is completely void, your lordship. Null and void, your lordship. The registrar doesn't have any right to instruct me to change my name until unless the amalgamation has been confirmed whether it has been done or not, your lordship. And the inquiry report itself says that till by that time we have registered, they haven't submitted any documents for the registration of the amalgamation, your lordship.
This is 89 and 90 and amalgamation certificate and
In that writ petition,
yes, your lordship,
we are challenging the amalgamation.
No.
No, my lord. We haven't challenged amalgamation, but we have challenged the present writ petition we have challenged. The pending writ petition we have challenged amalgamation strictly. Yes, my lord. Yes, yes. That's why, my lord, my humble submission is this.
Pending writ petition.
Yes, pending writ petition, my lord.
You are
Notice has
challenging-
been issued already, my lord, in the writ petition, and it was listed yesterday, my lord. And my learned friend, they have also filed applications, my lord, and the state government is now the
Maintainability, my
the-
lord, for filing
anyway.
the writ petition pending.
maybe,
before the court.
maybe, but they have already appeared. State
Maintainability.
government has already appeared. So, my lord, all these things can be taken together and heard together, my lord. All that I am praying is this, my lord. I am not praying to allow my appeal.
This page 108 and 109. This is the order of amalgamation.
Yes, it is just, man. This is the certificate given by registrar.
And the order.
For amalgamation, for my lord, registering this Hockey Manipur, the respondent here in my lord, on the ground that these are amalgamated by two association. But
In that pending writ petition.
yes, we challenge, my lord.
Have you challenged this?
Yes, yes, my lord. We have challenged everything. We have challenged everything, my lord. We have challenged on the ground that it was never done on the, as per the rules. It is not amalgamation not in proper way, and they have never filed any amalgamation application to the registrar. They just file and give a representation to the minister only, also, and minister directed. It cannot be done that way, your lordship. With great respect, your lordship. Yes, my lord. My learned friend can
So
start.
according to you,
Yes, ma'am.
their registration has not been done in terms of the rules.
Yes, yes, man. Their amalgamation was not done as per the rules, so their registration is wrong, and their registration is null and void as per the role of the in the eyes of lawyer lordship. So, my
On the
lord.
other hand also,
Yes, ma'am.
even your registration is under some cloud,
Yes, my lord.
correct?
Yes, my lord. So, my lord, I hold that I am submitting this your lordship. Even though my registration issue was never challenged by anybody till today, all that they are saying that there are two names, similar names, so my name should be changed. That's the only directions. But still, my lord, all that I am submitting is this, my lord. I am not praying to allow my writ petition. I did appeal your wish and causing this honorable single bench judgment, and let me proceed and let me scot free. I am not praying that, your lordship. All that I am praying is this: kindly, my lord, cause this set aside this single bench order and remand it back for hearing afresh, along with the amalgamation the issues, your lordship, so that matter can be decided permanently for good, whether in my favor or their favor, your lordship. Well, and my lord, by tomorrow, my lord, tomorrow, my lord, by chance, your lordship, if my writ petition regarding amalgamation is allowed, in case, my lord, and this order stands, then there will be conflicting, my lord. So, my lord, then you'll get more problem, more litigations. So all the price, my lord, to solve the problem for good, permanently. And your lordship must be aware, lordship, we have approached them many times. We are in the interest of the sports, many times for reconciliation. Even on the standard list, combined together form an association for the sake of the sports, for the sake of hockey in Manipur, your lordship. Yes, madam.
My lord, may I submit, my lord? With all respect, my lord. Lord, before going into the merit of the case, my lord, I will answer, my lord. I would like to protect the judgment passed by the single judge. I'll do my level best. And therefore, my lord, straightway, my lord, before going into the merit of the case, my lord, let me refer to para 56, page 35/51 of the judgment of the learned single judge of the writ appeal number 27 of 2022.
Page number?
My lord, this 50, Lord, 54, para 54 of the internal, para 54, my lord, is 35/50. This has been answered all the submission made by my good friend, my lord. Let me read out with the permission, my lord. At this juncture, learned counsel for the Manipur Hockey. My lord, there are two hockey association. My lord, I belongs to Hockey Manipur, and my good friend belongs to the Hockey Manipur. It's sometimes confusing while I'm submitting the petition. Now, Hockey submitted that Manipur Hockey is the only body affiliated and recognized by the Hockey India and the MOA. Manipur Olympic Association, MOA, my lord, long form, for the sports of hockey in the state of Manipur. According to Learned Channel Council for Manipur Hockey, Manipur Hockey is the body which has conducted tournament at different level in the state of Manipur, and on the other hand, Hockey Manipur has not undertaken not a single activity worth its name, and in other words, it exists only a paper. This is the crux of the issue which Learned good friend has submitted before Lordship more than 2 hours. Now, my lord, let me refer to next page, para 56. Para 56. It is true that Manipur Hockey has conducted many tournaments at different level in the state, and equally, Hockey Manipur, it is me, my lord, has also participated in various national and international level hockey matches. That is not the issue to be decided in the present petition. Therefore, this court has not delved into the issue qua conducting of tournament and participation of Hockey Manipur and Manipur Hockey at different level in the state. Once identical name exists, whether a society association can be registered under the identical or too nearly resembles is the point to be considered in this case. This is the only crux of the issue to be considered, and it was considered by the learned single judge. All the storytelling before your lordship is that in regard to the amalgamation, my lord. I'll come later on, my lord. I'll come later on that. What was the prayer of the writ petition? What was the statement meant in the writ petition? Had it been made everything, learned single judge would have passed the very order otherwise. Now, once an identical name exists, whether a society association can be registered under the identical or too nearly resemble is the point to be considered in this case. In this regard, as stated supra, section 10 of the Act clearly prohibits registration of a society which is identical with or too nearly resembles. It is the admitted case of Hockey Manipur, Manipur Hockey, is that at the time of its registration, Manipur Hockey Association and Manipur Women Hockey Association were in existence. Now I just read out before lordship two things. One is certificate, one is order. Thereby cancellation of the two associations which was registered in 1976. The very other issue, it goes to show the non-existence. Before that, two associations were very much active. On the basis of that, learned single just pass order. Now this is the answer, I suppose it is the answer to the whole stories of my good friend. Now what is to be considered now? Now let me refer to this, my lord, with the permission, my lord. There are 4 sections involving here in this case, my lord. The first section is the, my lord, section 7, read with rule 5. Second section is, my lord, section 10, read with rule 13. And then, my lord, section 12, that is amalgamation, read with rule 15. And again, section 11, read with rule 49. Now, before going into the details, my lord, let us understand what is the section. I suppose, my lord, you also must be having the...
Yes.
Yes.
You want to section?
My lord.
You want to come to the act?
My lord, I wanted to refer to your lordship with the permission. This is the only deciding the learned single judge on the question of law, my lord. Now, section 10, my lord. No society shall be registered under a name which is identical with or too nearly resembles the name of any other society or any body corporate which has been previously registered in or incorporated under this act. Under this act. Or an other law for the time being in force as the case may be or is deemed to have been registered under this act. Now, my lord, procedure of the section 10, your lordship. Rule 5. Section 10, my lord, that is, your lordship, rule 13. Rule 13, your lordship. We will go the provision of section and rules, my lord, how to process for, implementing the correct section. Rule 13. Similar or nearly similar names and identification under section 10. When an application for registration is received, it shall be examined in the office of the Register of Society whether society of similar or nearly similar names have already been registered in the office. Other books of records which may give a clue to this shall also be checked up. The same process shall be done when a proposal or decision or change of name of the society is received. Before registration, the change of name publication shall be made by the society in the widely circulated local newspaper, inviting objection to the registration under the name or change of the name. The objection shall be submitted within 15 days from the date of publication of the Register of Society. This has been, Your Lordship, is rightly pointed out, there is a gray area or in respect of the registration matter that is on record. Now, this is the section talks about, Rule 13 and Section 10 talks about. Now, let me refer to Section 7 because Manipur Hockey has been registered under Section 7. Registration. Manipur Hockey is going to registration certificate. Yes, can no, my lord. Yes, you Section 7, my lord. Let me read out with the permission, my lord. The registered, upon being satisfied that the memorandum and the regulation accompanying it complied with the requirement of this Act and rules, and upon payment of the fee referred to in subsection 2, shall certify under this hand and seal that the society is registered under this Act, there shall be paid to the registered for the registration of the society of a society under this Act a fee of 100 rupees or such smaller fee as the state government may from time to time direct. An appeal shall lie to the state government against an order of the registrar refusing to certify the registration of an association as a society under this Act, and decision of such appeal shall be fined. Now, rule. Then, my lord, let me refer to Rule 5. What is the procedure to be done to implement the Section 10? Rule 5. Application for registration of under Section 7, my lord. An application for registration, my lord, this is, my lord, lordship made. It's not required because this is the rule to be followed under Section, 7. Now again, let me read. Your lordship, Section 11. Section 11 is empowering to the state government. If there be any identical and nearly resemblance, if the facts discover, then the state government has power to direct to the society to amend the memorandum of association and the change of name. Now let me read the section 11. Section 11. State government may direct change of name. If a society is registered under a name or alter its name to another name, which in the opinion, my lord, opinion of the state government is identical with or too nearly resembles the name of any other society or body corporate which have been previously registered or incorporated under this Act or any other law for the time being in force or being deemed to have been registered under this Act, continue to exist, the state government may, by order made in this behalf, direct such society to change its name and alter its memorandum within 3 months from the date of the order on such longer period as the state government may think fit to allow. Because how the order was passed said to be impugned order before the learned single judge, by invoking this 11, state government has opinion, in the opinion of the state government, if there be an existence of the earlier two associations, namely Manipur Hockey Association and Manipur Women Hockey Association, it was non-existence only on yeah. Yes, my lord. just I have pointed out two. One is registration of the Hockey Manipur amalgamating body, and another order is the seizing, cancelling the registration on the same day, meaning thereby to on that day, two associations were very much active. Therefore, learned single judge straightway go to that because it is purely question of. Now, therefore, my lord, sub close to 11.2, my lord. No change of name shall affect the right and the liability of the society or any legal proceeding by or against the society. Your lordship. Now, let me refer to section 12. Section 12. Society to have power to amalgamate with another society. These are the, four sections, my lord, and 4 rules heavily relied upon by the learned single judge and passed this very order. So, society to have power to amalgamate with another society. Whenever 2 or more society desire to amalgamate, the governing body of each such society shall submit a joint proposal in writing to the register of his prior approval thereto. No such proposal shall have effect unless the proposal with the modification, if any, suggested by the register is confirmed by 3/5 of the joint member of the society concerned. An appeal shall lie in the state government against any order of the state government on such appeal shall final. If there be grievances in respect of the improper or amalgamation, my lord, not according to the procedure, then there is a provision for filing appeal. That appeal should have been filed within 30 days. Now they have filed the writ petition after 10 years, 20 years, 13 years. To that regard, to that fact, I have filed the miscellaneous application questioning the maintenance. You should have first go to the state government. State government is the final authority. Explaining the delay. But I'll explain that later on. I brought those writ petition pending before the learned single judge. I brought what is the prayer in the writ petition. So number 3, an appeal shall lie to the state government against any order of the state government on such appeal shall be final. On the proposal being confirmed, the amalgamated society shall be registered under its new name. The registration of the amalgamating society shall be cancelled, and the asset of the liabilities of the amalgamating society shall be the asset and the liabilities of the amalgamated society. Now, let me refer to the rules. Rule 14, no? Rule 15. Rule 15, which are relevant to, section 12. Procedure to amalgamate with another society under section 12. Rule 15. You got it?
Yeah.
Oh, the society intending to amalgamate shall discuss the proposal for amalgamating the society in a separate meeting of its governing body of the society, and the resolution shall be taken to the effect that the societies be amalgamated as per the provision of the Act. Joint meeting so and so, so and so. Joint proposal of amalgamation of the society shall be submitted to the register so and so, so and so, so and so, so and so. Now, these are the procedural matter up to 30 has been let down in respect of the amalgamation. That is very clear. Nobody can run away from this. That is very clear. These are the 4 rules involving the very case. So therefore, in order to appreciate the case and in order to appreciate the, judgment passed by the learned single judge, my lord, before going into the merit of the case, I just want to understand what is the, act and rules herein involved in the writ petition and the memo of appeal. Now, let me refer to the first of all, my lord. Let me refer to the writ petition. The first submission, which your lordship consideration. 9/16/2019, my lord, start from page 40. Lordship may kindly see. Start from page 40, my lord, 9/16/2019. Now, let me quickly go to prayer. Your Lordship, prayer is page 66. What was the prayer in the writ petition before the learned judge? By filing this writ petition? C, page 66. To issue a writ in the nature of certiorari, or for quashing the order bearing number 8/7/2009, corporation dated the 22/1/2018, issued by the Secretary Corporation Government of Manipur, directing the petitioner to change its name and alter its memorandum within 3 months from the date of receipt of the order. Now, D. These are the primary prayer, others are all general prayer. To issue a further writ in the nature of mandamus, directing respondent 1 and 2 to consider and dispose of the representation dated 29/12/2017 submitted by the President Manipur Hockey. Now, Your Lordship, 22/1/2018, my lord, herein page 152. And the representation herein page 146 to 151. Now, what was the prayer made in the writ petition? Now, is there any statement of irregularity, illegality in issuing the certificate in respect of the amalgamation? Is there any pleadings? No. Let me refer to, my lord. Only, my lord, if Your Lordship, para 10 of the writ petition. Para 10 of the writ petition, Your Lordship may kindly see. Para 10 of the writ petition, internal page 52. No pleadings, nothing is therefore in regard of the irregularities and illegalities committed while amalgamation of two bodies and forming the Hockey Manipur. Let me read out with the permission. Para 10, that only after registration of the Petitioners Association under the Society Registration Act, the President and General Secretary of Hockey Manipur submitted an application bearing number 12/11/2009 to the Honorable Minister, Cooperation, informing the letter about the amalgamation of the Manipur Hockey Association and Manipur Women Hockey Association to one unified body called Hockey Manipur, and also requesting for allowing the same amalgamation. Now, Your Lordship, what I'm reading out, because if Your Lordship read all the pleadings, Your Lordship may find the word amalgamation herein, only herein, and then another, para 30 of the page 63. Page 63, man. No statement, no pleading, nothing which my good friend has submitted before, Lordship, challenging entire, amalgamation proceeding, my lord. As I submitted, what, Your Lordship, that had it been submitted, everything, my lord, irregularity which is submitted by my good friend, my lord, then the order would have been otherwise. Now, let me read out para 30. That the petitioners humbly submit that the registration of the respondent number 3 under the Manipur Society Registration Act was allowed only on 21/1/2010. That is Manipur Hockey. Hockey Manipur. Much later than the registration of the petitioner, which was allowed on 12/11/2009. My lord, this is the crucial date. They are saying that our registration, but my lord, I am using the word, it is not the registration, it is the allotment of the number of the two associations, which clearly stating in the certificate. Now, much later than the registration petitioner, which was allowed on 12/11/2009. What they say is that the certificate was issued in favor of the Manipur Hockey 12/11/2009, registered under Section 7. And here in this case, Section 12, amalgamation process. It is the flow, the source of law, registering the two associations is different. Now, my lord, in view of such undisputed fact, the invocation of the provision under Section 11 of the Manipur Society Registration Act 1989 and Rule 49 of the Manipur Society Registration Act by the respondent number 1 against the petition instead of against the respondent number 3. My lord, that too, by totally ignoring the application dated 29/12/2017 submitted by the petition is very much arbitrary, malafide, and same has been done in tolerable exercise of power with an ulterior and the preconceived motive to cancel the registration of the petition at the cost by hook or crook. It's accordingly submitted that so and so, so and so. These are the basic central issue for filing the writ petitions. So, my lord, directly comes to the prayer, as I stated before, lordship. Now, my lord, here, your lordship, I have filed a rejoinder to the counter to the writ petition, and government also filed the counter affidavit. They have not filed any rejoinder. And to another case which I filed before the learned single judge for praying for implementing the said to be impugned order before the learned single judge. That also they did not file any counter plea. Now, your lordship, now prayer, as your lordship I have pointed out. Now, then thereafter, this is the prayer, okay, Manipur register, as a register. Yes, your lordship. This is the writ petition. Now let me refer to your lordship counter affidavit filed by the respondent. It's very important. Counter affidavit filed the respondent, my lord, that is, your lordship may kindly see page 169. Got it? 116. This is the counter filed by the respondent number 1 and 2. That is, my lord, that is, your lordship. Principal Secretary, Corporation Government of Manipur, and the Registered Cooperative Society Government of Manipur. Now, this counter affidavit is short, but it is very precise. If you lordship look at yes.
May it please the lordships. In addition to the submissions made on the last occasion, we have one more submission for your lordship's consideration. Now, I'll just formulate my submission, what exactly we are trying to say. The formulation is this. The executive power of the state under Article 162 of the Constitution do not, or rather cannot, extend to subjects transferred to the BTC. And therefore, the impugned notifications dated 4/6/2021 and 10/6/2021 are without authority of law. So essentially what we are saying that the legislative and executive power are coterminous. They exist together. So if you do not have the legislative power on the subjects transferred, can you be exercising executive power on that? Our contention is no, and I'll make good the submission. Now, would lordship first, having given the, please lordship have one Article 162 for a moment of the Constitution. May I just place it? Article 162, extent of executive power of state. Subject to the provisions of this Constitution, the executive power of a state shall extend to the matters with respect to which the legislature of a state has power to make laws, provided that in any matter with respect to which the legislature of a state and the parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this constitution or by any law made by parliament upon the union on authority or authorities thereof. Now, please mark the first paragraph. The legislative power of the state will only extend to those subjects on which it has the power to make laws. Now, having seen Article 162, kindly come to the accord itself, which is at page 131, and I'm, Lordship, Annexure 1, page 131, because we have to understand the extent of powers that was granted to the council. Please come straight to clause 5, which is at page 132. Bottom of the page, clause 5, power and functions. I'll read it very, very carefully, Lordships. The 5.1, the council shall have legislative powers in respect to subjects transferred to it as enumerated below. All laws made under this paragraph shall be submitted forthwith to the governor and until assented to by him shall have no effect. The BTC shall have executive, administrative, and financial powers in respect of the subjects transferred to it, which would essentially mean, obviously, if you have the legislative power, this power is coterminous. This is in the spirit of 162. So therefore, with respect to the subjects transferred, it is the BTC who will have the power to make laws. Now, please come to see, kindly come to clause 5.7. In the context of the notifications that we are challenging, what does it say? The offices of the Deputy Commissioner and Superintendent of Police will be outside the superintendence and control of BTC. Now what it says is that the powers have now been given to the DC, who is not under the administrative control of BTC. Please see the incongruity. That means you are giving executive power on one hand, but on the other hand, you're taking away the officers from your jurisdiction. Now, please, after having seen 5.7, would Lordships then come to the 6th schedule itself? Because we haven't placed the 6th schedule, actually. What does the 6th schedule envisage? What is the extent of autonomy that the 6th schedule envisages? So please take up the 6th schedule. In fact, for your Lordship's convenience, I had seen the constitution, it is not properly placed. So we have just got print out. In fact, I also saw that, but it is, the amendments are not properly placed in the correct. Now please come straight to the 6th schedule, Lordship. I'll point out some clauses. First, Lordship will kindly see clause 3. Because then we will understand what is the extent the constitution envisages, the extent of powers that these councils are being given. May I draw your Lordship's attention to clause 3. Powers of district councils and regional councils to make laws. The regional council for an auto. I'm so sorry. Yes, clause 3. Powers of the district councils and the regional councils to make laws. 1. The regional council for an autonomous region in respect of all areas within such region and the district council for an autonomous district in respect of all areas within the district except those which are under the authority of regional councils, if any, within the district shall have the power to make laws with respect to. I am not for the moment taking you to the subjects. Then Lordship will see the next page, 3B. Sorry, not next page, the page thereafter. In addition to the subjects enumerated in clause 3, this is 3B, which is actually applicable to us. Additional powers of the BTC to make laws. Without prejudice to the provisions of paragraph 3, the Borough Territorial Council within its area shall have the power to make laws with respect to. Now, these are the 39 subjects that is now enumerated in the Constitution. And I will just draw your lordship's attention to X 30, Seriatim 32. Please see Seriatim. There are many subjects. Please see Seriatim 32 for a moment. Planning and development. It is the BTC alone to whom this power has been transferred.
22.
32 lordships.
Yes.
Sorry, lordships. 22. I'm sorry, it's not 32. 22. I'm sorry, 22. Then lordships may see 40 as a sample.
40.
40. Welfare. All these subjects now stand transferred to the DCs, whereas we have the legislative power. Now, the next clause which lordship will see in this context is clause 12A. Very
paragraph.
Para. I'm sorry, para. I'm so grateful, lordships. Para 12A. In fact, there is no automatic application of laws to this region. A law may be existing, but it doesn't automatically apply. It has to be applied by a special order. Application of acts of parliament and legislature of the state of Assam to autonomous districts and autonomous regions of Assam. 12, lordship. Notwithstanding anything in this constitution, it's a non-obstante thing. No act of the legislature of state of Assam in respect of any matter specified in para 3, that is 3B, or para 3A, or para 3B, that is what I showed just now, lordships, of this schedule, as matters with respect to which a district council or a regional council may make laws, and no act of the legislature of the state of Assam prohibiting or restricting the consumption of any non-distilled alcoholic liquor shall apply to any autonomous district or autonomous region in the state, unless in either case the district council for such district or having jurisdiction over such a region by public notification so directs, and the district council in giving such direction with respect to such district or region or any part thereof have effect subject to such exceptions or modifications as it thinks fit. So therefore, lordship will, what we are trying to emphasize is kindly see the extent of autonomy given to these councils under the Sikh schedule. The constitution recognizes it. Then lordship will come to para 13.
30.
13, 1-3, 1.
Yes.
Now see the financial autonomy as envisaged by the constitution. Para 13. Estimated receipts and expenditure pertaining to autonomous districts to be shown separately in the annual financial statement. The estimated receipts and expenditure pertaining to an autonomous district, which are to be credited to or is to be made from the consolidated fund of the state, shall be first placed before the district council. Please mark the word district council. I'll show what now the dilution that has happened. For discussion, and then after such discussion be shown separately in the annual financial statement of the state to be laid before the legislature of the state under Article 202. So therefore, the entire financial planning in terms of 162, the spirit of 162 is first the council will decide and then it place it before and it will become part of the subset of the main state budget. Now, having seen these provisions, would lordships for a moment come back to Annexure 3, the OM dated 6/10/2004, which is at page 146, because this is the OM that immediately followed the second Borough Accord. This is the OM dated 16th October 2004, Annexure 3. May I just place second paragraph of this? Mr. Chaudhary read it. I would just want to read it in the context of what we are arguing. Whereas the government of Assam, wide notification number so-and-so dated 31st October 2003, adopted and approved the aforesaid MOS and resolved to extend executive powers to 40 subjects, departments listed in Annexure 3 of the MOS. Whereas the governor has been pleased to entrust and delegate the functions relating to 39 subjects, departments, excluding Relief and Rehabilitation Department, listed in para 3B. This is what I've shown. Please see the connection. Listed in para 3B of the 6th schedule as amended of the Constitution, and to which the executive power of the state extends. So now what they are saying that we are now transferring it to you in terms of 3B, which Lordships had placed. Now kindly see clause L. Clause L, which is at page 151. I just now placed para 13, the financial autonomy. Now, this is what was envisaged. May I just place clause L? The Bodoland Territorial Council shall prepare the estimate of receipt and expenditure pertaining to the Boro Territorial Council in respect of the entrusted subjects, departments, as per the allocation norms, etc., communicated by the state government. The Boro Territorial Council in their council session shall consider the estimated receipts and expenditure pertaining to Boro Territorial Council in respect of the entrusted subjects, departments, and send the same along with the synopsis for consideration to the state government within the stipulated time as provided for in para 13. So it recognizes that power of the 6th schedule of the Constitution of India. Ordinarily, no change will be made in the estimated receipts and expenditure as considered by the Boro Territorial Council in respect of the entrusted subjects, departments. However, for any reasons, if it becomes necessary to do so, the council shall be consulted and reasons for the proposed change shall be made. The state government then they'll place the estimated receipts and expenditure as considered by the Boro Territorial Council along with the synopsis before the state legislature as provided for in para 13 of the 6th schedule of the Constitution. Next, M. Boro Territorial Council authority shall prepare a plan with the amounts likely to be made available for development works both under the state share and the center share, covering any or all of the activities of the departments under their control. The council shall have full discretion in selecting the activities and choosing the amount for the investment under the same in any year. The plan will be a subset of the state plan and will be treated as its integral part. Once the plan of the state, including BTC plan, gets approval of the Planning Commission, the BTC authority shall start execution of the plan in the BTC areas. Last line, BTC will have a planning department to prepare the plans for BTC to be submitted to the Planning Commission through the Government of India. Then Lordships N. All centrally sponsored schemes, central sector schemes, NEC schemes, externally aided schemes, etc., in respect of the entrusted subjects, departments for which fund will be released by the state government to the council as per the sanction and released by the Government of India to the state government shall be implemented as per norms and guidelines of the Government of India and the state government. O is very important. The BTC will exercise its legislative powers as conferred under clause 3B of the 6th schedule of the Constitution of India. This OM recognizes this. Now, having seen this, Lordships, now let us go to the impure notifications, how they play foul of all what we've argued. Please see the first notification, that is 4/6/2021, which is at Lordships 1, which is at page 174. Third Boro Agreement number 4th June 2021. 199, Lordship. I'm so sorry. 199. This is a notification of 4th June 2021. please, may I please, in pursuance of the transferred subjects. Now, they are also recognized, it is in respect to the transferred subjects vested with the Borough Territorial Council by the 6th schedule of the Constitution of India Amendment Act so and so, dated 7th September 2003, and the notification number so and so, dated 19th January 2021, issued by the Personal Department of the Government of Assam, relating to implementation of the Memorandum of Settlement signed on 27 January 2020 between the Government of India, Government of Assam, and Borough groups. The Deputy Commissioners of the Borough Territorial Council, that is the Deputy Commissioners of Kokrajhar, Chirang, Baska, and Udalguri, are hereby entrusted with overall monitoring and supervision of the schemes pertaining to following subjects entrusted with the BTC. And if Lordship will see clause 5.7, which takes away the administrative control of these very officers from the BTC. And then these subjects are, there are 16 subjects, and then the last, the Deputy Commissioner will be responsible for oversight and supervision for the district and subdivisional level officers regarding implementation of various schemes by the Government of India, Government of Assam, and BTC authority for above mentioned subjects. Further, they will prepare an annual plan and get it approved by the Principal Secretary BTC. Now, where is the role of the council now? It is they who will prepare the annual plan and get it approved by the BTC's Principal Secretary. So what happens to the para 13, which envisages the district council? Who shall do this? And where is the power now that these subjects already stand transferred to the BTC? Where is your, how do you extend your executive power to this? Is the question. Then Lordship will see the other notification, that is the other improved notification, which is 10/6/2021. Is this 10th June 2021 notification. Again on the same lines, again on the same page 201, Lordships. Again on the same line, that in terms of the spirit of 162, you could not have issued this because you don't have a source to issue this power. In the interest of public service, the Governor of Assam is pleased to order the creation of a new administrative department, namely the Welfare of Borough Department, with immediate effect. The department will be the nodal department for formulation and implementation of policies and programs for welfare and all-round development of people inhabiting in Borough land area under the 6th schedule of the Indian Constitution, under 6th schedule of the Council of the State. Now, I have demonstrated that the entire planning and development has been transferred, the subject has been transferred to the BTC. How do this department, where is your, essentially your source, which you are exercising? Secondly, the department will also be responsible for implementation of tribal sub-plan of the state, annual plan, central and state government funded programs in the Borough area under the 6th schedule. Please have a look at the OM that I just placed and this, the dilution that is taking place. Please see seriatim 6 of this notification to run, control, and monitor the schemes, programs implemented in the BTR. 10 to take up such. So essentially what they are saying is that the entire, in a very indirect and a very smart move, they are diluting the power. They're giving us the power. The Constitution gives us certain power, which is now being sought to be taken away by executive action in which they don't have legislative competence. So therefore, in addition to what was submitted last time, we reiterated that on these transferred subjects, the state could not have exercised this executive power because the legislative competence to legislate on these subjects stands transferred to BTC, not only by the OM, but what is envisaged in the Constitution amendment itself. Because if para 3, if Lordship will see additional powers, para 3B, additional powers to the BTC to make laws. And in all these subjects are enumerated. I am so grateful. That's all. I'm so grateful for very patient. No problem.
Maitri, Your Lordship. In this case, I am appearing on behalf of the state of Assam as well as the BTC. Before placing the facts from the perspective,
Can you appear for both? Can you appear for both? Class of interest. Maybe, no? Maybe. You are appearing for both the BTC and the state of
yes, there is
Assam.
no conflict. In
There's
fact,
no-
I can appear on behalf of the central government also. Because they are challenging the act. Therefore, I would like to place the prayers first.
Okay, okay.
Yes. We have done a lot of exercise on this now.
Oh.
So Lordship will kindly come to page 120. What is their first prayer? A declaration to the effect that tripartite memorandum of settlement, third Borough Accord, signed on 27 January 2020 between Union Government, State Government of Assam and leaders of APSU, UBPO, NDFB, 4 factions as a whole, and on specifically clause so and so, so and so. So they have challenged the whole accord, the memorandum of settlement, MOS. And who are the signatories? The central government, the state government, as well as the various factions and various organizations. I will place that accord. In that case, where we are having an agreement, the state of Assam, the BTC, as well as the central government, as well as other frontal organization of BTC, they do not have any conflict. The conflict is with the persons who have lost miserably in the election. This is purely a political exercise done in this honorable court. I will give appropriate response to all the constitutional issues they have raised. But if Lordship is pleased to look at, because this is the third accord, who are the signatories of the first accord and second accord? There is some modification of the second accord, some more additional things were added for development of BTC area. Now let us see who are the writ petitioners here, the petitioners here. And thereafter, I will take your Lordship to the accord. Now, Lordship, if Lordship is pleased to come to the clause title. Yes, Lordship will kindly come to page 8. And I hope they will not have any objection to my appearing for both BTC and the state government.
We don't.
They don't have Lordship. So we don't have any conflict. One is Borough Writers Academy, Kazalgaon, represented by, I have no issues on that. This is an authority. I do not know whether this is a registered authority or organization. I have no knowledge. Second is a political personality. So and so, his identity, Lordship will find he was a former MP. Third is Chandan Brahma. He was a former EM of BTC. The earlier one till 2019, and they were signatories of the earlier accords. Then fourth is Kampa Borgiari. Fifth is Hitesh Bosumatari. These are all political personalities who are rival with the present regime and who lost election, and out of, I do not know what is the reason, they have lost this petition with addition to some other individual persons. So when they have signed the agreement, they have no issues. And when they enjoyed power for 15 years, there was no issue. Today, they lost the election and better agreement has come for betterment of BTC area, more funds, more infrastructure, more accommodation, more bringing the persons who are not in the mainstream, bringing them to the main fold. Now they have problem. Citing various consider, we have done the exercise, we'll place everything point by point. But first, we have to understand what is this accord all about and who are the signatories of this accord, who are the signatories of the earlier accord, what are the transferred subject, what is the role. All these things are regarding the legislative power. Nobody is legislating now in BTC, neither central government nor state government. All the submissions which my learned friend have just made, those were laws, those were provisions regarding legislation. Those notifications were not part of legislation. So there is a fundamental error. The foundation is not there. Assam government, neither central government is going and to BTC and formulate any law there. What we are doing, Lordship, will kindly come to the accord, the third accord. Let us start from the reverse way. So they have basically challenged, Lordship, 120 once more. They want a declaration to the effect that tripartite memorandum of settlement, that is third Borough Accord, signed on 27 January 2020 between Union Government.
Page.
Page 120.
The prayer.
Prayer part, Lordship.
Oh.
A declaration to the effect that tripartite memorandum of settlement, that is the third accord, signed on 27 January 2020 between Government of India, that is Union Government, number 2 State Government of Assam, and the leaders of these organizations as a whole. So they want the whole accord should go. This is first prayer. Or alternatively, they want clause 3.1, 3.1, Roman 2, Roman 3, clause 3.2, clause 3.3, clause 3.4, 4.4, 7.2, 8.1 as ultra vires of the Constitution. So either the whole act should go or a part of the act should go. So therefore, we have to see what this act is all about and under what circumstances this accord was signed by the various stakeholders. And they have also challenged, Lordship, page 122, the notification of 28 September 2020, prayer E. D also, that 28/9/2020, then another notification, page 123, H, 19/1/2021, and another one at J, page 124, 4/6/2021. So they have challenged the accord or part of the accord and these three notifications they have challenged. But before harping into the other things, let us see the facts as it is. The first Bodoland Accord, the second Bodoland Accord is at page 131. Memorandum of Settlement of Bodoland Territorial Council, BTC, 10 February 2003.
This is the second accord.
This is the second accord. First was in 1993. When the first extremist group, they came overground. But till that time, Lordship, this BTC was not formed. Here, may I read it, Lordship? Because we have to compare the second accord with the third accord. The second accord, the writ petitioners were party, or their political party was a party. The Government of India and the Government of Assam have making concerted effort to fulfill the aspirations of the Bodo people relating to their cultural identity, language, education, economic development. Towards this end, a series of talks were held between Government of India, Government of Assam, Bodo Liberation Tigers, BLT, since March 2000. So BLT was an underground organization, it came overground. As a result, it is agreed to create a self-governing body for the Bodo areas in the state of Assam. Objectives. The objectives of the agreement are to create an autonomous self-governing body to be known as Bodoland Territorial Council. Now we want to make it broader with BTAD, a different term. That notification is under challenge. So Bodoland Territorial Council, BTC, within the state of Assam, and to provide constitutional protection under 6th schedule to the said autonomous body to fulfill economic, educational, and linguistic aspirations and the preservations of land rights, socio-cultural and ethnic identity of the Bodos, and speed up the infrastructure development in the BTC area. Area 3.1. The area of proposed BTC shall comprise of all the 3082 villages and areas to be notified by the state government. The above mentioned villages and areas shall be divided into 4 contiguous districts after reorganization of the existing districts of Assam within a period of 6 months of the signing of the agreement on the lines of the proposal given by BLT, subject to clearance of the Delimitation Commission. 3.2. A committee comprising of 1 representative each from the Government of India and Government of Assam and BLT will decide by consensus on the inclusion of additional villages and areas in the BTC from out of 95 villages and areas on the basis of criteria of tribal population being not less than 50%, contiguity or any other agreed relevant criteria within period of 3 months from signing of the MOS. This criteria was still resorted to in the new attempt to demarcate or delineate the whole area. This same criteria is being followed now. Status of Bodoland Territorial Council. The provision of the 6th schedule and other relevant articles of the Constitution will apply to BTC, mutus mutandis, in terms of this agreement. The safeguard modification and for the non-tribal in BTC area, inter alia will include the following. The provisions of para 2 of 6th schedule regarding autonomous region will not be applicable to BTC, and there are certain conditions. Coming to clause number 5. Powers and functions. The council shall have legislative power in respect of subjects transferred to it as enumerated below. All laws made under this paragraph will be submitted forthwith to the governor and until assented to him shall have no effect. The BTC shall have executive, administrative and financial power in respect of the subjects transferred to it. Then the subjects lordship will see at next page, subjects to be entrusted to BTC by Assam government. 5.3 lordship will see. The BTC shall have the full control over the officers and staff concerned with the delegated subjects working in the BTC and shall be competent to transfer officers and staff within BTC area. ACRs of these officers shall have to be written by the appropriate BTC authority. Then next, page 134, 5.7, which are relevant. I am reading only those parts. The offices of the Deputy Commissioner and Superintendent of Police will be outside the superintendents on control of BTC. 5.10. The executive function of the BTC shall be exercised through its principal secretary, who shall be an officer of the rank not below the Commissioner Secretary to the Government of Assam. The sanctioning power of the Government of Assam shall be vested with the Principal Secretary of BTC and sanctioning power of head of the department, including technical sanctions, etc. Page 135. Grant of ST of BTC Kasaris of Karbi Anglong and NC Hill districts. These are not contiguous areas, these are separate districts, Lordship. So for their interest was also taken care of. Then 9, development of Bodo language. The Government of India agrees to consider favorably the inclusion of Bodo language in Devanagari script in English 8th schedule of the Constitution of India. Bodo language shall be the official language of BTC, subject to the condition that Assamese and English shall also continue to be used for official purposes. Then additional development package for BTC. The state government, within the limitation of financial and other constraints, may offer or allow the council to offer possible and sustainable additional incentives for attracting private investment in the council area and also would support projects for external funding. So the state government will have to provide funds. In order to accelerate the development of the region and to meet the aspirations of the people, the Government of India will provide financial assistance of 100 crores per year per annum for 5 years for projects to develop the socio-economic infrastructure in BTC areas over and above the normal plan assistance to the state of Assam. The size of the corpus will be reviewed after a period of 5 years. Suitable mechanism will be built in the system to ensure that the funds are transferred to BTC in time and at regular interval. An illustrative list of projects which may be considered to be taken up in BTC given below. So list of projects were given in that original accord, second accord also. Then 11, centrally funded university. Then rehabilitation and relief. Lordship will kindly, this is little bit, it has importance, relevance here. why this accord was signed, Lordship. And it is more elaborated now in the third accord. The BLT would join the national mainstream and shun the path of violence in the interest of peace and development. After the formation of the Interim Council of BTC, BLT will dissolve itself as an organization and surrender with arms within a week of swearing in of the Interim Council. The state government will provide full support to relief and rehabilitation of the members of BLT who would surrender with arms in this process in accordance with the existing policy of the state. Financial support in such cases, however, shall be limited to the provisions of the scheme prepared and funded by the Government of India. Withdrawal of cases against such persons and those related to overground Boro movement since 1987 shall be considered according to existing policy of the state of Assam. The Government of India will initiate steps to review and action against the Boro employees of Government of India and subordinate officers, as well as in respect of central government. Undertaking similar action would also be taken by the Government of Assam. Next page, Lordship, 137. Immediately after signing of the agreement, Interim Executive Council for BTC shall be formed by the Governor of Assam from amongst the leaders of the present Bodo movement, including signatories of this settlement, and shall include adequate representation of the non-tribal communities in BTC. The Interim Council shall not continue for a period beyond 6 months, during which period election to the council shall be held. The Government of Assam shall dissolve the Bodo Autonomous Council BAC and repeal the BAC Act that was from 1993. It was in operation. The Government of Assam will consider inclusion of all tribals, including Bodos, in RH, AC, and MSC and LSC with consultation with the leaders of this council. These are other councils, Lordship, which are not to the level of 6 schedule areas. That is RHAC is Rabha Assam Autonomous Council, MAC is, I think, missing, and LS another tribal council. The implementation of the provisions of the Memorandum of Settlement shall be periodically reviewed by a committee comprising of representatives of Government of India, Government of Assam, and BTC. This is also important because this was not final continuously. There was an effort to upgrade it. Signed on 10th February 2003 at Delhi in presence of Sri L.K. Advani, Honorable Deputy Prime Minister of India, Sri Tarun Gogoi, Chief Minister of Assam. So the signatory from the BLT side was Hagrama Bosumutari, Chairman, P.K. Datta, Chief Secretary, Assam, and R.C.A. Jain, Secretary, Ministry of Home Affairs, Government of India. So there were 3 signatories. And presently, the Chief Executive Member, CEM of Bodoland is Pramod Boro. He belongs to APSO. And from 2003 to 2019, Hagrama Mohilari was the Chief Executive Member of that council, who was at the helm of affairs in BTC area for 3 consecutive terms. And the writ petitioners, they belong to the same party. Page 9, Lordship. Under his council, serial number 3, Chandan Brahma. Chandan Brahma later became the minister in the state government also. Then Kompa Borgiari, Hitesh Bosumutari, they were all part of this same political party. They formed Bodoland People's Front, BPF. Once they gave up the name Boro Liberation Tiger, they formed a political party called BPF, Bodoland People's Front, BPF. So till that moment, there was no conflict with any of the provisions of the constitution. Now, when they lost the power, they started this issue. Now, Lordship will kindly come to the objectives of the 6th schedule, page 138. As these are part of the petition, so I am reading it from there only. So once that a memorandum of settlement was done, then there was a constitutional amendment. In the present case also, my submission would be, the first submission in my case would be, Lordship, it is a premature case. They have challenged the notifications which were issued. Number one, to constitute a commission as provided under paragraph 14 of the 6th schedule. They are requesting the people to give their suggestions. Some of the villages, there is less number of non-tribal, so the understanding is that those non-tribal populated villages should be out of the purview of BTC, and some villages where the population of tribal is more, they should be included in BTC. Those recommendations the governor has sought to the state of Assam, which is under the scheme of things. Once the suggestions comes and the recommendation is placed, then it has to be placed before the assembly. Thereafter, and once the suggestion is, then there can be objections also. That when that exercise was started, this repetition came up. So that is why it is a premature case, and that cannot be done without there is a consequential or subsequent constitutional amendment. So this Lordship will kindly see the date here of the second Bodo Accord, which is at page 131, 10th February. Lordship will kindly mark this, 10th February 2003. Memorandum of Settlement on Bodo Territorial Council. So 10th February. So after that, it was necessary to amend the constitution, more particularly 6th schedule of the Constitution of India. This is the statement of objects and reasons of the 6th schedule to the Constitutional Amendment Bill, page 138. The provisions of the 6th schedule to the Constitution of India have evolved a separate scheme for the governance of the tribal areas in the state of Assam, Meghalaya, Mizoram, Tripura through the district councils or regional councils. There are 3 parts in the table appended to the schedule. They are so divided in order to distinguish the areas. The areas in part 1 represent the tribal areas of Assam. Each of these areas constitute an autonomous district. The provisions in paragraph 1 to 17 of the 6th schedule relate to the administration of these autonomous districts. The councils are vested with legislative power on specified subjects and are allotted sources of taxation. They have also been given power to set up and administer their system of justice, maintain administrative and welfare services in respect of land, revenue, forest, education, public health, etc. The Bodo Accord was signed on 20th February 1993 with all Bodo Students Union and Bodo People's Action Committee with the objective. This is the first accord, Lordship, of 1993. The Bodo Accord was signed on 20th February 1993 with all Bodo Students Union and Bodo People's Action Committee with the objective to provide maximum autonomy to the Bodos within the framework of the Constitution for social, economic, educational, and cultural advancement. In pursuance to the Bodo Accord, an interim Bodoland Autonomous Council BAC was constituted by the government of Assam by enacting state legislation. Bodo groups were of the view that Bodo Accord had become unworkable due to non-implementation of the accord in letter and spirit. Based on the tripartite talks, a memorandum of settlement has been signed between the central government, the government of Assam, and Bodo Liberation Tiger on 10th February 2003 for a durable solution to the Bodo issues. To meet the aspirations of the Bodos in Assam and in pursuance of the MOS, it is proposed to create an autonomous self-governing body to be known as Bodoland Territorial Council within the state of Assam, which shall have legislative, administrative, and financial powers in respect of the specified subjects. 2, provide an adequate safeguard for the non-tribals in the BTC to ensure that they are not put to any disadvantage in relation to any rights and privileges, including land rights presently enjoyed by them at the commencement of BTC. The bill seeks to achieve the above subjects. Now, 10th of February, that was done. The accord was signed. Now, page 140. the sixth schedule to the Constitution Amendment Act 2003 dated 7th September 2003. So after the accord was signed and after a series of actions, the amendment had taken place at the Parliament. An act further to amend the Constitution of India in its application to the state of Assam, be it enacted by Parliament in the 54th year of the Republic of India as follows. So 2, there is an insertion. In paragraph 1, after subpara 2, the following provisions shall be inserted, provided that nothing in this subpara shall apply to the Bodoland territorial area districts. Then there are a lot of insertions. Basically, this amendment brought the existence of Bodoland Territorial Council, BS. In 5, after paragraph 3A, additional powers which my learned friend has placed. Page 144. All this amendment had taken place by duly considering the existence of the Memorandum of Settlement. So the Memorandum of Settlement has some meaning, and on the basis of which the Parliament has amended the sixth schedule accordingly. In our case, the third accord, it has been signed, certain action has to be taken. Thereafter, the amendment will have to take place. That is why my submission would be, it is a premature case at this stage. First, we cannot amend it. Then we can go for the notification for changing of the boundaries of the districts or the areas. First, we have to know where is the demand, where is the necessity that there should be any addition or subtraction of areas which can be included in BTAD now. For that, notification was issued, opinion was sought, objections were sought. At this stage, the stage is still in that position. That committee, the commission till now has not given any opinion. The chairman passed away midway, Lordship. Therefore, the replacement, things are going on. Once that recommendation comes and it is debated in the Parliament Assembly here, thereafter it will be sent to the central government for appropriate amendment of the sixth schedule. Those things have not taken place till now. There are things that whether we can do it or not. Now the issue is whether we can do it or not. They have done it already. 15 years they enjoyed their work. Now another political entity has come and taken their position. So now they are trying to find out the loopholes in the constitution. But there is absolutely no loophole. Whatever is done, it is within the scheme of the constitution, and more particularly the sixth schedule provisions. Today they have placed the sixth schedule. I am going to place it elaborately, Lordship. Page 144, second last paragraph, Lordship. In 10, in paragraph 19, after subpara 3, the following subparagraph shall be inserted, namely Roman 4. As soon as possible after commencement of this act, an interim executive council of Bodoland Territorial Area District in Assam shall be formed by the governor from amongst the leaders of the Bodo movement, including the signatories to the Memorandum of Settlement, and shall provide adequate representation to the non-tribal communities in that area. Provided that the interim council shall be for a period of 6 months, during which endeavor to hold election to the council shall be made. Next page, the explanation part, which I am going to highlight. For the purpose of this subject, subparagraph, the expression Memorandum of Settlement means the memorandum signed on 10th day of February 2003 between Government of India, Government of Assam and Bodoland Bodo Liberation Tigers. So, in the amendment also, due weightage has been given to the MOS. October 2003 page. This is not very important. Now, what I am trying to now, let us go to the present one. That lordship will find it page 155. Page 155. This is the third accord, which is under challenge now. The government of India, the government of Assam have been making concerted efforts to fulfill the political, economic, social, cultural, and identity-related aspirations of Bodo people. Tripartite agreements in 1993 and 2003 were signed, leading to creation of Bodoland Autonomous and Bodoland Territorial Councils under 6th schedule to the Constitution of Bodo, for Bodo inhabited areas in Assam. APSU and its associated organizations, as well as various factions of NDFB. This is another faction, Lordship, just like the BLT earlier. As well as various factions of NDFB continued with the demand for separate statehood. Negotiations were held with Bodo organizations for a comprehensive and final solutions to their demands while keeping intact the territorial integrity of the state of Assam. So this is the background, Lordship. There was continuous demand for separate state by bisecting Assam, and NDFB was taking the main role with these various factions. And there are a series of negotiations involving Assam government, central government, and the leadership of the NDFB. Because BLT, they have surrendered in 2003, they came overboard and they formed and they took the political responsibility of BTC for 15 years. 3 terms they won. 2004, then 2019, then again 15-16. This time they lost the election. So therefore all these complications have evolved. So negotiations were held with Bodo organizations for a comprehensive and final solutions to their demand while keeping intact the territorial integrity of the state of Assam. Before going to the various clauses, let Lordship see who were the signatories here. Page 159. The above agreement is signed on 27 January 2020 at Delhi in presence of Honorable Union Home Minister Sri Amit Shah. Number 1 signatory General Secretary APSU, Lawrence Islary. And one of the writ petitioner number 2, was a former office bearer of APSU. His own party member. Now he is not holding that position. He is no more office bearer. I'll place everything is in the record. The next person who has become the General Secretary of APSU, he is the first signatory. Who is second? President APSU Pramod Boro. So Pramod Boro is present CEM of BTC or BTAD now. Next page, Ranjan Doimari, one of the tallest leader in BTC. Ranjan Doimari, NDFB, he signed. Govinda Bosumatari, another tallest leader of BTC area. Third one is B. Sauranga, another NDFB top leader. Dhirendra Boro, another top leader of BTSC. Then Mahindra Bosumatari, President UBPO. Then the Chief Secretary of Assam, Joint Secretary of Ministry of Home Affairs, and it was signed in presence of who are the witnesses? One is Hagrama Mohilary, who was the CM of BTC from 2004 to 2019 or 2020, sorry, 2020. And Hagrama Mohilary himself was the signatory earlier. I am just getting a little bit confused. Hagrama Bosumatari signed it in 2003, page 137. And he was the chairman of Bodo, and the same person, later on his name, here it is Mohilary. I think it is the same person, Lordship. Same person, it is confirmed. So second accord was signed by him. Third accord, he was a witness. Signed signing of this agreement is witnessed by Hagrama Mohilari, CEM BTC. So at that point of time, Pramod Boro was not the CEM. Later on, election held, and they lost. They won the election. Hagrama Mohilari and his party lost the election. Pramod Boro and his party won the election, and they are at the helm of affairs now. They are holding the power. Then the present chief minister, as cabinet minister, he was there, and the chief minister of Assam, Sarbananda Sonowal, also was a signatory. So when Hagrama Mohilari, he signed in 2003, there was no conflict with the provisions of constitution. Now he is a part of the signatory of the third accord. He is also there. He is not a writ petitioner, but his whole party members are there. Now let us see what are the contents of this third accord. Objective of the memorandum of settlement, that is of the third accord. The objectives are to augment area and power of BTC and streamline its functioning. All these things are new, Lordship. NC Hills, the Dima Hasao Lordship, was formed in 1955. Same with Karbi Anglong Autonomous Council. From 1959, these are in function. So with lot of changes, they have come into a very comfortable position. How the things are moving, how the funds are utilized, how the development works are going. In this case, it is a new concept in BTC. So 2003, the baby was born. It needs some grooming. So that is why the third accord has come. And what is the line here, Lordship? Negotiations were held with Boro for a comprehensive and final solution to their demand while keeping intact the territorial integrity of the state of Assam, with the objective number 1, to augment area and powers of BTC and streamline its functioning. 2, address the issue relating to Bodos residing outside BTAD. There are huge number of Boro people living in Lakhimpur district, Karbi Anglong district, Dima Hasao district. So this accord is taking care of those Boro people also. To promote and protect social, cultural, linguistic, and ethnic identities of Bodos, which are in tune with the provisions of Constitution, Article 25 to Article 30. Provide legislative safeguard for land rights and tribals, land rights of tribals. We have lot of tribal bales and blocks where large scale encroachment is there by non-tribal people. So those 8 things are also taken care of. I'll place every clause here. To accelerate development of tribal areas and to rehabilitate members of NDFB factions. So these are the basic 6 main objectives. To augment area, Lordship will kindly note. That means both central government and state government are agreeing that to augment the area of BTAD. With a formula which was a part of the second accord, that 50% population of tribal people is the minimum requirement. Without changing that criteria, if certain areas there are more tribal people of Boro origin, we have other tribal people also, those areas should be part of BTAD now. It may not be contiguous. That exercise was undertaken by that commission under late P.P. Verma. He passed away during the COVID in 2022. So the work stopped, then a new person has taken over now. So with this object, that means to increase the area, and where required, we will dilute, we will take away some areas where their population of tribal is not enough, because the government, both the state government and the central government, will also have to look into the point that if there are less number of tribal peoples and they cannot be under the regime of 6 scheduled areas. 6 scheduled areas, what is the basic objective? To protect the culture, the livelihood, the customs, traditions of the tribal people with special emphasis. If those provisions are not required in a non-tribal area, that has to be withdrawn. That is what all these signatories have acceded and agreed, which includes the main stakeholders of BTC area, representing borrowed people. It has both the BTC, the BLT and the BPF representative, the NDFB, EPSU, these are the three main organizations, and UPBO, Mineshwar Basumatri, he is the president of UBPO, that is another major organization outside the BTC area. He represents Boro people who are not within the BTC area. He is a leader of the people who belong to Boro community residing in non-BTAD area or BTC area. So it is an inclusive and very exhaustive agreement which was signed on 27th of January 2020. So now what are the clauses here? Clause 3, this is, they have challenged. I'll highlight which are the clauses they have challenged. They have challenged clause 3. Yes, 3.1. Either the whole act clause, whole accord, or certain clauses. So the clauses which they have challenged is clause number 3.1.
Roman 2.
Roman 2. So alteration of area of BTAD. So a commission will be appointed under paragraph 14 of the 6th schedule to the Constitution soon after signing of the MOS to examine and recommend on the following. 1. Inclusion of villages contiguous to BTAD and having majority tribal population as demanded by Bodo organizations. So the first interest, what are the demands? Because after 2003, lot of people were agitating that why we are not included in BTC. We are not getting the benefit of schedule provisions. Large demand was there. So to include villages contiguous to BTAD having majority tribal population as demanded by Bodo organizations. There are contemporaneous record for this, Lordship. It is not that out of the air this clause has been inserted. 2. Exclusion of villages currently under BTAD which are contiguous to non-6th schedule areas and have majority of non-tribal population. There is a counter demand also. And government has to balance everything for proper peace and tranquility in the society. So those who were deprived of the protection under Constitution, they have to be given protection. They have to be brought under the regime of BTC area, 6th schedule provisions, and those who do not deserve that, they should be excluded. So that exercise was done. For that, Lordship, that legislative power and all those have no relevance. When BTC would like to formulate a law, because suppose they want to introduce lottery, or they want to have some excise laws or forest laws, those they can formulate. In that area, these clauses which my learned friend today argued are applicable. Notifying under paragraph 14. What is paragraph 14 of the 6th schedule? 6th schedule, a commission has to be constituted. Para 14 of the 6th schedule. Appointment of commission to inquire into and report on the administration of autonomous districts and autonomous regions. The governor may at any time appoint a commission to examine and report on any matter specified by him relating to the administration of the autonomous district and autonomous region in the state, including matters specified in clause C, D, E, F of subpara 3 of part 1 of this schedule, or may appoint a commission to inquire into and report from time to time on the administration of autonomous districts and autonomous region of the state generally, and in particular on the provisions of the education, etc., need for any new or special legislation, administration of laws, rules, etc., and define the procedure to be followed for such commission. The report of every such commission with the recommendation of the governor with respect thereto shall be laid before the legislature of the state by the minister concerned, altogether with an explanatory memorandum regarding the actions proposed to be taken thereon by the government of the state. In allocating the business of the government of the state among its ministers, the governor may place one of his ministers specially in charge of the welfare of the autonomous districts and autonomous regions of the state. So this commission was constituted. Constitution of the committee of this commission by itself per se will not change the geographical territory of a area of the district council or the regional council. Exercise was just started. After that, the governor may not recommend anything, any change. And if he recommends, it will be placed before the assembly. By whom? By the minister. Minister of whom? Minister specially allotted for development of the tribal welfare areas. So when a department has been considered, that also they have objection now. Earlier, WPT and BC department, welfare of tribe, Plains Tribe and Welfare Department. Now we have changed it to a Bodoland Welfare Department. There is no transgression of any rights of Bodo people by considering that that is under the scheme. The fund comes not directly to the BTC. It comes to the finance department. There is a special wing, and that department, with the approval of the governor, forwards the fund to BTC. There's a system there. And nobody is usurping anybody's power here or rights here. Whatever power and authority has been given by the Constitution of India, everybody is bound by that. So there is no violation. So this commission was constituted. Therefore, in the accord itself, in the memorandum of settlement itself, at clause number 3 says, 3.1 says a commission will be appointed under paragraph 14 of the 6th schedule to the Constitution soon after signing of the MOS to examine and recommend the following: inclusion of villages contiguous to BTAD and have majority tribal population as demanded by Bodo organizations. 2, exclusion of villages they are offended with 2 and 3. 2 says exclusion of villages currently under BTAD which are contiguous to non-6th schedule areas and have majority non-tribal population. This is under challenge. So I'll justify that also later on in my final arguments. 3, increase in constituencies of BTC up to the maximum of 60 seats after alteration in the area without adversely affecting the existing percentage of reservation for tribals. How they are agreed, I do not understand, Lord, for this. So the reservations and everything will remain intact. If more areas come, so there has to be a scope of delimitation exercise. There is a certain way of doing the delimitation exercise. And therefore, in one of the things, it has been already said that the area will be demarcated by consultation with the delimitation commission, the first accord. Then 3.2, the commission will include representatives of the state as well as other stakeholders, including APSU and BTC as its member. It will submit its recommendation within 6 months from the date of notification. So APSU is a signatory. BTC is Bodoland Territorial Council, Lordship. So their representative will also be there. They have to be elected to become a member of BTC. So the elected members, they have signed and they are part of the exercise. Those who have lost, they are aggrieved. That's why my submission was that they lost the battle of ballots and therefore this petition has come up. 3.3, the existing Bodoland Territorial Areas District BTAD shall be renamed as Boroland Territorial Region comprising area covered under BTAD. So that power is also there with the governor to change the name. I'll place that 62. That power is there to FF. In para 1, para 1 of 6th schedule, autonomous districts and council, double F. Double F says the governor may by public notification. 3 says para 1 subpara 3 FF. The governor may by public notification alter the name of any autonomous district. So they have to challenge this provision first, the constitutional provision. And this was agreed by all stakeholders who have won. In a democracy, the person who is elected by the people, they have the say. Otherwise, it will be chaos. If the opinion has to be taken from every person by excluding the elected representatives or the office bearers of the main stakeholders, public organizations, nothing can be done because 100 minds, 100 opinions. So in democracy, that federalism, I'll place all those provisions, all these observations of the Honorable Supreme Court, whose opinion is crucial, the elected representative. So 3.3 is also, it is also under challenge. So the existing Boroland Territorial Areas District shall be renamed as Boroland Territorial Region comprising area covered by BTAD. So it was agreed by all the stakeholders, including central government, state government, and the political representatives of that area. 3.4 is also under challenge. The government of Assam may consider reorganizing the districts consequent to the alteration of area of BTAD on administrative considerations. So that option is there, but that has not been exercised till now. Once there is a change of the area, after the commission submits its report, in case, in the event, then there is a scope that government can do necessary changes regarding the constitution of the districts for proper administrative reason. And that is not unconstitutional at all. This is pure from the point of view of administrative law. This is permissible. Next, review of powers and functions of BTC. The process of BTC to have more legislative, executive, administrative, and financial power in respect of additional subjects as enumerated in Annexure 1 will be initiated within 90 days. So more subjects are to be given to them. Why I should be aggrieved if more subjects are coming? Because my political opponents are able to get it. That's why I am aggrieved. That cannot be a ground. Principal Secretary BTC will have monitoring powers of registration departments with BTAD. Amendment to Article 280 of and the 6th schedule of the Constitution as per Constitution 125th Amendment Bill 2019 to improve the financial resources and administrative powers of BTC has been initiated. The Constitution Amendment Bill was introduced in the Parliament in January 2019. Executive powers of BTC shall be exercised through its Chief Executive Officer, not below the rank of Principal Secretary to the Government of Assam. Senior-most officers of various departments of BTC shall not be below the rank of Additional Chief Secretary to the Government of Assam. So earlier it was the Commissioner and Secretary, now it has been increased to Principal Secretary. They are challenging 4.4 also. This clause is also under challenge. Deputy Commissioner and Superintendent of Police of the district within BTAD will be posted normally in consultation with the Chief Executive Member of the BTC. So there is a scope for consultation now. Earlier, it was directly by the state government. So more responsibility, more weightage has been given to BTC. Deputy commissioners in BTAD will report to the chief executive member of BTC through chief executive officer in respect of all developmental activities in their districts with regard to the responsibility assigned to them by BTC. Nobody can be aggrieved by this. When the BTC chief is given the responsibility that deputy commissioners of BTC will report to him, they were posted by the state government. Why it has been done? Large scale corruption. And the BTC head have no control over the deputy commissioners earlier. To bring the deputy and to rein the deputy commissioners, now they are called district commissioners. This clause has been inserted here. How can this be illegal or arbitrary? Because one of their ground is arbitrary of challenge. A tripartite mechanism headed by the cabinet minister of the government of Assam, looking after BTC affairs, with the chief executive member of BTC and a representative of MHA as members, shall be set up periodically review, not less than once in 6 months, the status of all laws, regulations passed by BTC and sent to the state government for assent of governor. This 6th schedule itself says they have the right to frame the law, but it will come into force once the governor gives the assent. I have gone through one article. In some areas, 10 years also has elapsed. The governor is not giving assent. I'll place all those. So now, if 4.7 is inserted here to have a 3 members committee with the state government, the BTC area, and the central government also 1 member, so that the assent of the governor can be obtained at the earliest. So this is rather helping BTC to legislate, not taking away the power. A tripartite 4.8, a tripartite mechanism headed by the chief secretary to the government of Assam and having chief executive officer of BTC and a representative MHA as members shall be set up to periodically review not less than once in 6 months status of all proposals of BTC pending with the state government relating to creation of new post and posting of officers up to the vacant post. For creation of new post, Lordship always hears the finance department of the state of Assam. For creation of teachers post, they have to run from pillar to post, BTC. Those are the practical problems faced by various, including the BTC, the members and the chief executive council. In spite of they are willing to do things at the earliest, because of the red tapeism of various departments, this happens. So now, to activate the system and to have instant results, these are being inserted, these clauses. What is the purpose? For creation of new post and posting of officers to the vacant post. Then 5, provisions for Bodos outside BTAD. I'm reading it because they have challenged under Article 25 and 26 that this accord is taking, it is anti-Boro or they are against the culture and traditions of BTC, Boro people. It is hit by Article 25 and 26. Therefore, I'm reading this. Otherwise, these are not under challenge. If the whole act goes, then these will also go. 5.1, Government of Assam shall set up a Boro Kasari Welfare Council for focused development of Bodo villages outside BTAD. What the state government is proposing for development and protection of the culture and tradition of Boro people outside BTAD, where they have no control. For that, the state of Assam is proposing to set up Boro Kasari Welfare Council. In the lines of other existing councils for plain tribes, state government will consult Bodo organizations and existing councils before notifying areas to be included in the proposed Bodo Council, Bodo Kasari Council. An advisory committee comprising of the representative government of Assam, BTC and Bodo Kasari Welfare Council shall be set up to identify specific development needs for Bodo areas outside BTAD and advise the state government. Government of Assam shall take effective measures to confer rights under the Scheduled Tribe and other traditional forest dwellers Recognition of Forest Rights Act 2006 on tribals living in the forest areas outside BTAD in accordance with the prescribed procedure under the Act. Then regarding language, issues relating to identity, language and education, etc. Government of India will implement the commitment made in the earlier agreement in 2003 to include Bodo Kachari living in Karbi Anglong and Dima Hasao in the ST Hills of Assam in a time-bound manner. So large chunk of population is there in Karbi Anglong and Dima Hasao, that NC Hills Lordship, who are Bodo people. So their interest is also taken care of by this accord. Government of Assam will notify Bodo language in Devanagari script as an associate official language in the state, already done, Lordship. Government of Assam will initiate measures to provincialize schools and colleges established in BTAD and Bodo medium schools outside BTAD as per special need and requirement. The state government will also take measures to appoint lecturers in Bodo department in colleges outside BTAD as a special consideration. Government of Assam will establish separate directorate for Bodo medium schools in the state. So this is outside the area of Bodoland. A cultural complex cum center of excellence in the name of Bodofa Upendranath Brahmo will be established in Kulungapuri, Pukrajhar district. The center will study and recommend measures for protection and promotion of language, culture, identity, etc. of Bodo residing Assam as well as other states of India. The center will be managed by BTC with financial assistance from both central and state government. Nobody can have any grievance here, Lordship. Regarding the land rights now, they have challenged 7.2, but I will read both. Issues related to land rights, 7.1, Government of Assam may consider enacting a special legislation to provide adequate safeguards to lands rights of ST living outside tribal belts and blocks in areas outside BTAD. This is for general protection, Lordship, for tribal, not specific to BT, Bodo people of it. 7.2, Government of Assam will take effective measures to protect khas land, grazing lands and water bodies from illegal encroachment. Why they are aggrieved by this, Lordship, I do not understand. There is large scale encroachment of government lands, whether it is in BTAD area or outside BTAD area in the state of Assam. And government is saying under this accord that Government of Assam will take special measures to protect khas land, that means the government land, grazing lands and water bodies from illegal encroachment. So this is put to challenge. There is no rationale to challenge this. When the state wants to protect it, effective measures for protection, there are large areas everywhere. Sotras, Lordship, day in and day out, Lordship is taking those matters. The Sotra lands, how they are encroached by people of doubtful origin or immigrant Bangladeshis. So the government is taking special efforts and BTC should help here. Now 8. Special steps to be taken by Government of Assam, 8.1, that is also under challenge. Government of Assam will create a separate department to deal with matters relating to councils under 6th schedule to the constitution, including BTC. Fund has to be provided by, one portion has to be provided by the state. It has to be monitored. Whenever a new proposal comes, additional fund, creation of post, transfer, posting, etc. There are several administrative works which has to be done by the state government under the provisions of the constitution, 6th schedule. The state has a major role So if a department is there, it is already there. It is not that today it is separate department. Now the earlier department was looking after various aspects of welfare of tribal and backward classes people. Now an exclusive department is going to be created for which notification was issued. That is also under challenge under the accord. That department will exclusively deal so that the time requirement for implementation of various welfare schemes and projects, it will get activated. It will be more faster. So there also some objection is coming now in this writ petition. So Government of Assam will create a separate department to deal with matters relating to councils under the 6th schedule of the Constitution, including BTC. 8.2, Government of Assam will create one post of DIG in BTAD in addition to the existing post of IG. That is for law and order situation and various allied issues. 8.3, an administrative staff college will be established under BTC administration. Staff college will be there who will train the administrative personnel of BTC area by the Government of Assam, and the administration will be run by BTC. Objection. Government of Assam will provide financial compensation of 5 lakhs to each of kin of persons who lost their lives in agitations for separate state. People who have run the agitation, they are happy with it. And already that amount has been given in most of the cases. Now, 9. What actually triggered, Lordship? Settlement with NDFB faction. All NDFB factions under SOO shall abjure path of violence, surrender their weapons, and disband their armed organizations within 1 month of signing of this MOS. Government of India and Government of Assam will take necessary measures to rehabilitate the cadres in consultation with NDFB faction. Such measures may inter alia include lump sum payment of ex gratia, funding economic activities through existing government schemes relating to fisheries, piggery, organic farming, poultry farming, etc. Trade, vocational training based on locally available resources, recruitment in appropriate government jobs as per eligibility. A committee headed by IGP Special Branch Assam with representative of other departments as members will make an assessment of rehabilitation need of the cadres based on age profile, educational qualification, general areas of residence. The committee will also involve successful entrepreneurs, NGOs in this effort. Criminal cases registered against members of NDFB factions for non-heinous crimes shall be withdrawn by the Government of Assam as per procedure established by law. Criminal cases registered in connection with heinous crimes shall be reviewed case by case according to the existing policy of on the subject. Special development project package. The Government of Assam may earmark a sum of 250 crores per annum for a period of 3 years for development of areas under BTC. Government of India may contribute an additional fund of 250 crores per annum for the same period. Illustrative list of specific projects to be undertaken on priority under the special development package are appended as Annexure 2, 3, and 4. Bodo youths will be considered for recruitment in army, paramilitary forces, and police to increase their representation in the forces. Pre-recruitment training rallies will be organized by the agencies to facilitate the process. Joint monitoring committee. A joint monitoring committee shall be constituted with representatives from MHA, Government of Assam, BTC, and Boro organizations to monitor implementation of this MOS. So it was signed. Then Lordship will kindly see page 161, additional subjects. These are the additional subjects. Implementation of schemes under rural electrification, non-conventional energy, solar energy, renewable energy, mini hydel projects. This is one very important area. Welfare and development of minority communities, indigenous faiths. 3, trade and commerce with BTC subject to provisions of entry 33 of list 3 of the schedule of Constitution, Schedule 7 of Constitution. Medium industry to be added to small cottage and rural industries subject to provisions of entry 7 and 62 of the list 1 of the 7th schedule. Education to be added to animal husbandry and veterinary, that is to say that preservation, protection and improvement of stock and prevention of animal disease in veterinary training, practice cattle pounds. Technical nature to be added to flood control of protection of villages, paddy fields, markets and towns. Vocational education to be added to education, that is to say primary education, higher education, including vocational training, adult education, college education, general. Protection of wildlife to be added to forest. So these 8 additional subjects are given now. Then the infrastructure. Page 162. Educational other important institutions, Lordship will see. Upendranath Brahma Central University at Boroma, National Sports University, Sports Authority of India Centers at Udalguri, Baska, Sirang, Institute of Livelihood Management at Tongla, Northeast Regional Institute of Medical Science at Romari, Hotel and Tourism Management Institute, Regional Campus of Indira Gandhi, Borulan Movement Memorial Museum at Salibari, National Institute of Technology at Udalguri, Edishal Nobuda. This is from the central government. Then state government from another 11. Then next page, Lordship will see. Industries and employment generation projects. Government of India has 7 big projects, including railway coach factory at BTAD. Last one, 7. Then Government of Assam, formulation of sweeter industry by BTAD, farm machinery, etc., horticulture, park, animal feed plants, center for fishing breeding, Emporium Bir Silarai, rural resource center. So 9 from state government, 7 from central government. New infrastructure in Boroland, Annexer 4. Construction of highway in the name of Banaspur from Masbat to Halongi. Construction of bridges in Sankos River, Dhansiri, Bhairakunda. National Stadium for both indoor and outdoor events at Udalguri. Comprehensive drinking water scheme. Cancer Hospital and Medical College at Tamulpur. Already work started. Flyover at railway crosses at Goreshwar, Tongla, Udalguri. Overbridge on so-and-so. And Government of Assam, construction of embankment to protect erosion and inundation of rivers under river management project, upgradation of district hospitals, etc. Boruland Guest House at Mumbai. So, if Lordship comes to page 158, settlement of NDFB. 158.
Hmm.
158, clause number 9, settlement of NDFB, a huge expenditure is to be incurred by both central government and state government, and lot of incentives are given so that they give up the path of violence and come overground and mingle with the mainstream and lead a proper, effective, good economically sound life. Lordship will kindly come to page 136. So here, relief with serial number 12, relief and rehabilitation. At that point of time, it is the BLT. So BLT was Boro Liberation Tigers. So my humble submission is that, Lordship, whatever may be the reason, overall economic development is the necessity. So that the young youths, they do not go astray and take the path of violence. And as a result, law and order situations and whole ecosystem for development of the area goes haywire. So the efforts of the state government, efforts of the central government, as well as the persons who have realized, they understood that violence will lead to nowhere.
What is the full form of this NDFB?
National Democratic Front of Bodoland, NDFB. And it has 4 factions. All factions have joined here. The main faction,
Democratic front of
Bodoland. There are 3-4 wings of that. Everybody came.
4 factions.
A lot of efforts has been given by the central government as well as by the state governments. Series, years after years, negotiation. Then it has culminated to this accord. And after that, Lordship, we will not hear any violence news for last 3-4 years. There is absolutely zero violence in Boroli and lot of development work. In fact, the infrastructure there, Lordship, will not believe it is much better than Guwahati. The museums, the assembly house, etc., the stadiums, everything, the roads. It is not that I am trying to defend on that ground. No. Constitutionally, I will defend this accord. Where is the flaw? Which provision of the Constitution has been violated? Although it is not a legislation, but it has to be tested in the touchstone of the constitutional provisions. Whether anybody's fundamental right is infringed. The main group of the writ petitioners are all political personalities. And those who have signed now, they are also political personalities. And we are at the middle. This honorable court, we all. They have done the same thing. When they signed, there were how many stakeholders? 3 stakeholders. That's first signatory, page 137. BLT, the Boro Liberation Tigers, Government of Assam, and Central Government, 3 entities. Now, BLT has converted itself to this BPF. BPF is here.
Where?
BPF, Lordship will not get the name, but as CEM BTC last one, Hagrama Mohilari. And his council members are writ petitioners here. I think including the speaker. The last line, left hand side, CEM BTC. So he represented BPF. The organization whom he represented, he was the chairman of BLT. So BLT formed a political entity called BPF. Bodoland People's Front. So he is there. All the various factions of NDFP are there. And President UBPO. United Boro People's Organization. United Boro People's Organization. Plus the state government and the central government. They have taken a very holistic view. What is necessary? Where is the actual grievance? And Lordship will kindly come to the preamble part once more, Lordship, page 155. The government of India, the government of Assam have been making concerted efforts to fulfill the political, economic, social, cultural, and identity-related aspirations of Boro people. Tripartite agreements in 1993 and 2003 were signed, leading to creation of Bodoland Autonomous and Bodoland Territorial Councils under 6th schedule to the Constitution for Boro inhabited areas in Assam. APSU and its associations, so APSU was not a part at that point of time. APSU and its associated organizations as well as various factions of NDFB continued with the demand for separate statehood. Negotiations were held with Boro organizations for a comprehensive and final solution to their demands while keeping intact the territorial integrity of the state of Assam. EPSU is also there, that is in the previous 157, 59 page number. So Lawrence Islary, General Secretary EPSU, and Pramod Boro, President EPSU, page 159, and the NDFB people and the
EPSU full term is?
all Boro Students Unions. Very strong organization, Lordship, wide base. And they are now, they have formed up a political party, UPPL. They have formed a political party, and Pramod Boro is the Honorable Chief Executive Member of BTC Council now. So UPPL is now holding the field. Then NDFB people are there. United Boro People's Organizations is there. So they cover the whole entire society. And if Lordship is pleased to look at the identity of page 169. A memorandum was submitted by them, the writ petitioners. Lordship will see the first name, ex-MP Lok Sabha, former President and General Secretary of EPSU. He himself was holding that position earlier. So his own organization, please don't comment, don't comment. I do not want commentary or a reaction. I'm making submission to the court. I don't disturb anybody. So what I am trying to emphasize is that you are holding your own organization. That organization is a signatory there. So what I am trying to emphasize, that particular gentleman was himself a part of that organization, who is a part of this third accord. He is an ex-honorable MP of Lok Sabha, former President and General Secretary of EPSU, and EPSU is a signatory now. He is no more a student, that's why he has grown to a different level. Next is former chairman of Volunteer Force EPSU, Phukon Chandra Boro. Then former secretary of EPSU, former leader of EPSU. Then the registers of college. So my humble submission is that these particular persons, Pramod Boro and Louis Islary, they are also representative of the same organization. That is why I'm saying it has mass support base. It has more representative capacity. I have full honor, respect to the person who has filed a petition, petition number 2. He also was a part of that organization. That organization is very good, nicely favored by all people. People have confidence in that organization. That is a state organization. It is not by any Tom, Dick and Harry who have signed this accord on 27th of January 2020 in Delhi. The persons who has respect and command in Bodoland, they have signed. They are the signatories. And they are all holding political powers now. They are not, that's why I am directed, I was requested to represent them. There is no conflict with the state government of Assam and BTC, or to that effect, the central government. All are on same page. Same page with NDFB, same page with APSU, same page with the other organization beyond the territorial jurisdiction. So there is no conflict. That's why I made the submission. I can represent central government if the request comes. That is not my friend will appear. Ranjit Dev Chaudhary will represent the state government, central government. Now, another notification which is put to challenge is 28th September 2020. Page 175. This notification is also under challenge. In pursuance of clause 3.1 of the memorandum of settlement signed on 27/1/2020 by the Government of India, Government of Assam, All Bodo Students Union, National Democratic Front of Bodoland, the Governor of Assam is pleased to constitute a commission under paragraph 14 of the 6th schedule to the Constitution of India with the following members: Sri P.P. Verma, Chairman. Then number 2, Administrator BTC, Joyanto Busumatari, the Vice President of EPSU, Dalim Bayon, Red Cross Udalguri, Joint Secretary, Government of the Home and Police. These are the 5 members committee. The commission will submit its recommendation within 6 months from the date of this notification. This will come into effect from the date of issue of notification. So, on what ground they have challenged, I do not understand. The provision is there. This commission is given the terms of reference also. They have not annexed, but the terms of reference, I can, in our affidavit, we have mentioned what are the terms of reference. When I place the affidavit, then it will come into. But it is basically for the objective number 1. Objective number 1 says 1, 2, and 3. 1, 2. To augment area, that means to include area and powers of BTC and streamline its functioning. So area, for that area, this commission, plus along with the powers of BTC and streamlining of its functioning, to address the issues relating to boroughs residing outside BTAD, whether more areas from outside BTAD can be governed by the BTC Council from Kokrajhar. That aspect is also been looked into, to be looked into by the commission, so that the interest of the borough people in Karbi Anglong and NC Hills or Dima Hasao district lordship has to be taken care of, which was not there earlier in the accord. To promote and protect social, etc. So this committee was considered. This is put to challenge. Now, when this committee was in operation,
Just a minute, Mr. Barrow, this challenge to this notification. This challenge to this notification was on the ground that the person at serial number 4.
No, we are saying it is not representative of the society. We have read out the pleadings, we'll re-emphasize the pleadings. It is not representative. How does this, as Lordship has very correctly put it, what does this Red Cross gentleman have to do? I'm grateful, Lordships.
Then it has already been acted upon by people and they have annexed it. So Annexer 9, page 176. Prayer not to exclude the revenue village of Diwal Khanda from the Bodoland Territorial Council in view of the new area demarcation of BTR. With respect and humble submission on behalf of the citizens of so-and-so and inhabitants of its surrounding revenue villages, have the honor to pray before your honor that the Diwal Khanda is a revenue village and the boundary of BTAD under number 39 present Pansoi surfing constituency. That this revenue village has been existing from the time of British rule, whose 90% citizens are cultivators. In this regard, we the villagers of this Diwal Khanda village was included under the jurisdiction of BTC as per the Bodoland Accord, which was signed by the BLT, Government of Assam and Government of India on 10th February. It will be worthwhile to mention that from then onwards, this village has been taken new shape and started developing and growing in various terms, education, social and economic. So there is a demand that they should not be excluded. So it is been acted, but this is a fragile situation. No action has been taken till now. Then another notification, another representation, page 178, prayer for continuance of original position of Khanabari Aryani Part 1 and Khanabari Aryani Part 2 villages without any change. So there is a request from the inhabitants there. Then page 191, not to exclude Nilarbari, number 1 village, page 191, 193. So the committee will have to apply its mind. Will have to verify the request we'll have to apply the criteria laid down in the accord. What are the norms? What are the criteria on the basis of which a area can be put under BTC or can be excluded under BTC? That 50%, all those figures. So that exercise till now has been not done. Committee was constituted as per the provisions of the Constitution as well as the accord. Accord also says page 155. I'll clarify Lordship's query. Three point two. The commission will include representatives of the state government as well as other stakeholders, including APSU and BTC as its member. So if we look at it, and if we look at the notification, APSU representative is there, Jayanta Bosumatari, Vice President, All Bodo Students Union. Dalim Huya convener, Dalim Bayan convener Udalguri. Joint Secretary of the Government of Assam, Home and Political. So if any person who needs to be, then number 2, Administrator BTC. Number 2 in this list. So here it says the commission will include representatives of the state government as well as other stakeholders, including APSU and BTC. So BTC and APSU are included. Other stakeholder is Dalim Bayan. If they want anybody to be included, that can be a different cause of action. If somebody they wants that a person representing a particular organization needs to be included here. That is not the case here. Whatever was mandatorily, there should be a representative of APSU. So the Vice President, Jayanta Bosumatari of APSU is a part of that commission. Serial number 3. A representative of BTC should be there as a member. So the administrator of BTC is included here. So 2 persons by name, by designation, by position are indicated in 3.2. Other stakeholders, if they have any grievance against Dalim Bayan convener, Red Cross Udalguri, give a justification to the governor, he will definitely take a call. There is no, for that, the whole process cannot get derailed. Later on, this so requests, suggestions, objections, everything was forthcoming to the commission. Actually, one is the demise of the chairman. The other one is that 2 years, nothing progressed in the state lot because of COVID. 2020, 2021, Lordship knows how the situation was. These all were put into cold storage.
We can wind up for the day.
Yes, Lordship, I'll be happy. Next day I will place my affidavit and I will address one by one their arguments.
Meantime, you can also prepare your written arguments.
Yes, yes, we will do that. I was just trying to seek liberty from your lordship. First.
নাই নাই মই দিল্লীত আছো নাই মই এতিয়া সাত তাৰিখ মানে ল'ব লাগিব 5-6 দিনটো ইয়াতে তেওঁৱে ফিক্স কৰিব
Also heard Mr. D. Saikia, Leonard, Advocate General Assam. Mr. R.K.D. Chaudhary, Leonard, Deputy Solicitor General of India, from Bank of India. And BTC, who's happening?
I am appraising, I am assisted by Ranjit Musari.
Okay, R.K. Mushari, standing counsel, BTC. Part in part. When?
The seventh lordship.
No, my brother will not be there.
Then maybe
From 4th to 16. He's out of the principal seat.
Thursday?
yes,
20th, if lordship's convenient for us, 20th?
just 1 second.
Is it okay with you?
Could it be on 19th lordship?
19th of
Because-
Monday না করবো।
21 তারিখ আমার বাইরে যাব।
আচ্ছা, 19 করবো।
19-20 তক মই ঠিক কৰি দিম।
In fact, I was just wondering, how long will it take?
More time লাগিব।
One day?
1 day.
One more day?
Maybe more than 1 day. If a lordship is taking up at 2 o'clock, if it starts in the morning, by evening I will wind up.
So we'll not take much time. So, but next time we should, at least from our side, we should attempt to finish it up because I know it's very harsh on the judges also. We'll give a reply.
And I have to defect.
So, take it.
19th lot, 19th February.
19th.
Or
19th is fine.
19th.
At 2 first 10:30.
It's up to you. You want to have it from the.
From
From
the
the
beginning,
beginning,
from the morning.
Perfect. That would be ideal, Lordship. 10:30.
Then we're not putting time.
Yes.
Let it come as part of it.
Deeply up.
These are going to be reached.
Yes, ma'am. So, my lord, can it be fixed on next Tuesday, my lord, on 6th? Obligement.
As we got item 7, may I pray?
Yeah.
As we got item 7, maybe next week, lordship, subject to convenience and it's a little bit urgency with the lordship.
Give a date.
9.
My lord, item 9 and 10, my lord. The other side is there.
Lordship, I'm appearing for respondent number 2. Any date 12th or 14th March?
12th March, my lord.
Well,
March, man.
okay.
Deeply aware.
My lord, I want to mention item number 19 to 27. The matter may be taken on 8 February.
Lordship, 8 February, we have some difficulty, lordship. Last week of February, lordship.
27th.
In item number 8, my lord.
27th.
In item number 8, my lord. Next week if possible, my lord.
Is your analogous matter, isn't
My
it?
lord, some interim order there, from that may be continuous. Stay order may be continued
Two more.
from 19 to 27.
Item number 8, my lord. That may be taken up on next week if possible, my lord.
Yeah, M. Chandra.
Millard,
Oh,
have
5 minutes.
only 5 minutes, Millard. I humbly requested Millard.
Any date, my lord? It's convenient to your lordship, my lord.
Maybe 15 Millard, 15 at Impal, we have holiday. So I may come down on Thursday and Friday.
Or 15th or any date after
What
20,
date you have
2021.
Millard. 15 holiday, Millard, there is a Lungai. Because the festival of the.
But my lord, to be very frank, 15 is Valentine's Day. And going out of that, my lord, going somewhere.
Is it 15 or 14?
14 is 14 is Valentine's Day, so we have to leave on 13th.
14 we're having holidays in Goa.
So so my lord, any date after 20th, 20.
20.
20, yeah.
15,
16 is
I'm
better.
thinking of. Yeah, 15, 16, some problem may be there.
Okay.
Okay, give a date, it's up to you. You, both of you consult since you're going to come from Impal.
I couldn't share the matter.
Yeah, you can correct that. Which one? Tuesday, Thursday.
27 to the bureau.
27.
27,
Tuesday, bro. 27, madam.
27, your lordship. Your lordship is available then. Bench is available.
Okay, what is Biswajit Lenu, senior counsel, assisted by Kalita?
Yes, both of us. And you. Kalita,
Mr. Kalita, Leonard, counsel for the applicants. Also heard Mr. Hemchandra, then the senior counsel, assisted by Juno
Yes.
J. Raman, Leonard counsel for the respondents. Part in part. Please for the hearing on. When do you want?
27, madam.
27.
My lord, my presence may be recorded.
Also heard Mr. Athauba.
Yes.
Athauba. Government advocate.
Yes.
For the state response.
And my lord, James Haiwala sir.
Yes.
The same, yes. Haiwala sir is leading.
My lord, yes.
Not you.
Not me, my lord. Not me, my lord. Taiwala is leading the case.
Okay, instead of Hemchandra, then you put
Yes,
James Haiwala, the senior counsel, assisted along with Mr.
along with, yes.
Hemchandra, then the senior counsel, assisted by J. Raman and Mr. NAC. Hmm? For the-
Your lordship, brain is still very good because remembering J. Rahman, John O. Rahman.
Sometimes it functions, sometimes it goes off. Getting old.
Your lordship.
Yes.
In regard to item number 11, lordship, can a date be fixed, lordship? I am appearing on behalf of Mr. S. Datta for the appellant. I've taken the consent, lordship, from the other side. Can it be fixed on 8th of February? We have consulted the date. 8th of February. Deeply obliged.
Duly obliged.